please rise for the Pledge of Allegiance for this July 6, 2023 Planning Board meeting. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. So tonight, for everybody, we have Ken Gibbs back with us as an alternate. We made a recommendation to the select board, and they agreed with our recommendations, so welcome back, Ken.
He's back.
The other thing I would mention is that Mr. Madsen may not be here or may not be here at all. So I'll appoint alternates until he gets here. If he gets here in the middle of something, then the alternate will continue. And then last, when we get to Voodoo Holdings, because Ms. Cook is new on the board and hasn't been able to participate in the many meetings we've already had and watch the hours of tape, which is understandable, I will appoint an alternate for that as well. And Ms. Cook will act just like an alternate would. She's not recusing herself, she's just not voting on that. Okay? So the next order of business is the approval of minutes of June 26, 2023. Motion to accept by Mr. Harden. Is there a second? Second by Ms. Cook. Any discussion? And I guess I need to appoint an alternate for this part right now. So.
You always skip that.
I know. Well, I said I was going to, and then I didn't. So I'll appoint Kathy as the alternate.
No, I mean, you skipped the public comment part again.
Oh, well, I'll come back to it. All in favor, please raise your hand. Not yet.
Oh, yeah.
It's number 4.
We had a vote on that. Yeah.
The next
Never mind, you vote.
next item is public comment on any particular topic. I see there's quite a few there's a number of members of the public here, as well as applicants, and I'm just wondering, how many of you are here for a particular application? Okay. I know you guys are applicants, so I'm talking about the public. All right, when we, so is there anybody that wants to speak on either Stark Storage, Nuria, Sweden Millbrook, or 10 Lakes Medical Complex?
Chair, I will recuse myself for the Millbrook and join the audience.
Okay.
And I would like to speak at that time.
Okay. So are folks in the audience here, are there people that are going to want to speak about the applications before us? I'm just checking, because if you want to, I'll wait until we get to that stage, and we'll determine whether we're going to call a public hearing or not. So I'm just trying to get a feel for it. Anyway, we're moving on. Okay, next order of business. Does anybody have any other public comment they'd like to make before we get rolling?
Yes, Millbrook has one L in it.
Okay. I'm guessing that's what you're here for.
Named after the director of Millbrook.
Okay.
Whose last name was, or first name was Mildred.
We will take that under advisement, Laura Lee, right? Okay, so next on the agenda is old business, Voodoo Holdings, North High Street, map 13B, lot 10. We are continuing the public hearing. At our last meeting, we had provided, is Mr. Voodoo here?
No. I don't see him here.
I don't see him here. Is Mr. Voodoo aware that he needs to be here? Okay. What's that? That's up to you. I think we should go to the next item.
Well, he submitted the information, so he must know that,
He submitted the information, but I think the ordinance tells us
oh, yeah.
we don't
and I'm
proceed
saying he
without the
doesn't need to
applicant
be
being
I'm
here.
just saying, I'm surprised that he isn't here. since
So-
he's in trouble.
We'll move right on to Pit Stop Propane and Fuels, 4 Raspberry Lane, map 6, lot 24. You have before you the findings and fact and conclusions of law. You'll note that the one that's in the OneDrive has a few items in red. That's because those are corrections I found, grammatical corrections, after I did the original one. So they're all grammatical corrections or slight restructuring of sentences, except for on page, I guess it's 9. I've added something to the section on municipal services in terms of emergency response that I had forgotten that was brought up by the chief in answering a question, which is this sentence: "The fire department and emergency management personnel train for these various emergency situations on a routine basis." So if everybody's okay with that, then we'll go there. And for Pit Stop, because Angie wasn't able to be here for that deliberation, Kathy will go ahead and, well, actually, both Kathy and Ken will need to vote on this. Okay. All righty. Is there
I'll make a motion to approve with the corrections.
a motion by Dan Harden to approve with the corrections? Is there a second? Second by Dee Miller. One other thing is, I put an XXX concerning the height of the tanks. I was able to go to the drawings, and I've just put less than 20 feet. It's easily less than 20 feet.
Okay.
Okay? All in favor, please raise your hands. Ken, you can raise your hand or not for this, you deliberated on it.
Okay.
All right, 5-0. All right.
I believe they're here if you want to. Okay.
Yeah, and I think what we want to do is, you want us to sign the Mylars, correct?
Yeah, we still call them Mylars, but yeah, the paper.
Yeah.
They've become paper.
That's a Mylar, it's a little dusty back there.
Yeah.
Yeah, whatever. So why don't we sign those now?
Okay.
Timber. See, that's why I don't like those water bottles.
Yeah,
Where would you like, do you want to do it?
Don't do it right there.
yeah. You can do it here. Yeah. And I guess we have to sign.
I think you do.
Yes.
Just off some.
You have a special pen or?
I put the name on it, signifying the event, but you can use that.
All right, because he used it with the bylaw for this.
Oh, you did. Don't want to mess with
It's like our chair sign.
art, and flat surfaces.
Oh, you need some more?
Oh, you're a chair. All right, I'm after you. We have to leave space for you anyway, we might as well let you be first.
Thank you.
Only those two, right?
Correct.
Clean table.
Thanks, Dan.
Do we need to redate, or are all the dates going to be consistent?
Might as well read it.
You want to date?
Just to
Okay.
be present event. Okay.
She has one?
Yeah, either.
You could, no, here, you can use my pen. Here.
But again, you know. You know. Ken.
You already signed one.
Oh. Saw one. One hand, one hand. Here we go.
Yes, yeah,
And
you should have that pen enshrined.
like the president does, he signs one little letter.
Yes, you need,
Oh,
you need the pens to be passed.
She did a wonderful job with these findings. I mean,
Yes,
it's
it's-
on like a Supreme Court argument.
Yeah, that is one of the things that she does well, and that it's a real arduous task.
thank you.
Thank you.
Is there anything else to say?
We will, just waiting to get to the next topic and then
Okay.
let things clear out.
Good luck.
Okay, so could I ask how many people are here for Voodoo Holdings?
One.
One? Okay. He is obviously not here right now, and so we can't continue the public hearing without him. So we'll just keep going on the agenda at this point. So on to new business, Stark Storage Amendment, North High Street, map 12, lot 22. As Rolf is not here, I'll continue to have Ms. DiPietro as the voting member. Okay, so, before we get going, the applicant has standing. Locations map 12, lot 22. Proper notices have been sent. Does anybody wish to recuse themselves? Okay. Do we believe the application is substantially complete? Okay. I do have things I want to see, but I'm good with where we are right now. Do we feel we need a public hearing? There has been quite a bit of public comment on this and some conflict. But, Dee?
Well, the public comment is virtually the same as during the original
Okay.
application. So I think we've had ample time to respond to that. There seems to be nothing
Oh.
new. And,
Okay, so I don't see anybody raising their hand for hearing. Is there anybody in the audience that came here specifically for Stark Storage?
Just the one up at the podium.
Nope, just the lady, yes, I know, the applicant's agent.
We did have people coming, and on our agenda it says 6:15, so.
Oh.
Oh.
Because I know people have called today regarding.
6:15.
That's right, because Mr. Boodoo's not here.
So
Right.
we're an hour off, which is very clearly stated that these are just approximate times, so.
Well, let's do it this way. So we have a couple choices. If we know people are coming, we can either go to 5B and work through things, and then come back to this at the regular time. Or we can just go ahead and the board always has the option of hearing public comments or calling a public hearing at any time. So, you know, what I would say is if 10 people walk in and we haven't deliberated, we may want to think about whether we call a hearing or not. Okay? How's that sound?
Whatever.
All right. If you could state your name and just give us an overview of the application.
Sure, thank you. Good evening, my name is Suzanne Burnell. I'm an attorney with Vinyl Benton Branch, and to be externally lit. So, as mentioned, the property address is 1161 North High Street. It is located in the mixed-use corridor. Justin Roma is here as well. He is the owner and president of DN Roma Engineering. And he was part of the initial application and approval. So any questions I can handle in this room. Quick history on this, February 24, 2021, this planning board conditionally approved the site plan for the construction of a self-storage facility, and the final approval was issued on March 16, 2021. The owner did initially request an internally lit sign. However, a condition was imposed by the planning board to not allow an internally lit sign. As you know, internally lit signs are allowed as a matter of right in that particular district. The board imposed the condition that the externally lit sign was required in order to, and I'm quoting, maintain the character of the wooded and natural dark corridor and to not detract from the nearby properties in the area. So we have reviewed many documents, very familiar with your town, which is a great town, by the way. I enjoy driving through. But however, we do not find anything in the performance standards that require a standard of maintaining the character of a wooded or natural dark corridor. Performance standards state that any permanent sign, and this is your standard, shall not detract from the design of other surrounding structures and properties and shall be constructed, installed, and lighted in a manner not to present potential damage to the value of adjacent properties. The adjacent properties to our locus are vacant lots. I do not see how an internally lit sign is going to have any impact on the vacant lots. If we move past the adjacent properties, which again is not required by your standards, but to go outside that, that area, it's sort of an industrial feel, even though there are some residential properties there. They tend to have large garages, they're storing equipment, but generally the locus feels industrial in nature. And obviously you all know the town well. It's a major thoroughfare going through the town. The proposed lighting is what we call de minimis. It poses no damage or damage to the value of the adjacent properties. There would be no spillover light. And the locus is large, it's 5 acres. The light is far from any neighboring property, and the light just simply doesn't travel that far. The sign is located at least 75 feet from the street. The sign is neat and clean in appearance. I did provide a project narrative, which I hope you all have, because it does have pictures in it. If not, I have additional copies.
I think we have that, yeah.
The last page on that project narrative has a picture of the actual sign, so that you can see what we're talking about. Everybody good? You want me to go forward, or we want copies?
No, I think we all have that.
Okay. So the sign is internally lit, provides safety to the self-storage users. It provides effective orientation and identifying the business location. So the business has been there for 2 years, and the applicant tells me that people don't know he's there. They don't see the sign. People that have scheduled, visits or are actually engaging go right by it. And the problem with that, obviously, on that road is 2 things. They're either going to miss the sign entirely, which is going to require them to make a U-turn, or they're going to see it very late, slam their brakes on, and make a really hard turn. So both of these are safety issues. I mean, the underlying thought on signs is that it does identify your businesses so that people that are going there can find them. So I think that the fact that there's no lit sign there at night, no one can see the business, and that is a safety issue. Additionally, in Maine, as we all know, there can be significant snowfall. So the request that it be externally lit is problematic. So if you're using those gooseneck lights, the snow falls, hits the gooseneck, now it's pointing over there, it's pointing over there, it's pointing over here, it's pointing anywhere but the sign. And that can also be a safety issue because that gooseneck light is now out on the street, it's indirect to some other property owner. Additionally, if you go with the can lights, again with the snow and the nature of the weather here in Maine, they can be completely covered. So there again is no lighting available if you're doing an externally lit sign. Also requires more maintenance for the sign. The bulbs need to be changed more frequently, again, because of the weather here in Maine. Across the street from our locus, there is a street light. That light is providing more illumination on Route 302 than the street sign. Than our subject sign. I'm also advised that there's a newly approved large parking lot across from the locus where there will be significant parking. I assume that also will have lighting. So lighting concerns there. Just please keep that in mind when you're deliberating that you plan on having some significant lighting coming in there while not allowing this particular applicant to have an internally lit sign. I did speak with the sign company with regard to the bulbs and the illumination. Was there anything unusual? Was it particularly bright? They said, nope, these are the bulbs they use as a standard light. Every sign that they produce that's internally lit uses this same wattage, so nothing unusual here with the particular brightness of this sign. Internally lit signs are allowed in the subject zone by right, as you know. We are unable to locate any provision which prohibits an internally lit sign simply because one doesn't exist in the town. Obviously, that is a rather silly argument. We'd still be living in caves if we never made forward progress. So the fact that presumably there's no lit sign in that zone, there should never be a lit sign in that zone. And in our project narrative, you will see that we have numerous internally lit signs, and there are in fact 2 located in the mixed-use zone. The veterinarian clinic and a restaurant. Each of these boast an internally lit sign. So consequently, the argument that internally lit sign does not exist in the mixed use is invalid and not a reason to deny the applicant an internally lit sign. Exhibit A in the project narrative shows photos of both of those signs for the vet and the restaurant. The existing sign was approved by the town. Bailey Sign Company submitted a building permit application all or about July 29, 2022 for the installation of a new pylon sign. The application was approved by the code enforcement officer for a new sign in accordance with the town sign ordinances. With this approval, the town made a determination that the sign met all of the zoning ordinance requirements and performance standards. This application was for a new sign and not the sign approved by the planning board because that one could not be internally lit and the application was for an internally lit sign. The town's ordinance allow an applicant the option of going to the planning board or the code enforcement officer, and the permit was issued on August 2nd, 2022, and based on that, they installed their internally lit sign. We maintain that the existing sign has been legally approved by the town and consequently constructed, and we reserve all rights afforded thereunder for an appeal and further recourse necessitated by the action of the town. That being said, we are hopeful that the planning board will also confirm the sign as legally conforming and existing to bring a final conclusion to this matter. The applicant would like to conduct business in Bridgton in full compliance and harmony with the laws and ordinances. So in conclusion, the sign meets all zoning requirements and the purposes previously determined by the code enforcement officer and is outlined in section 1 of the sign ordinance, which is, and I quote, to encourage the effective and safe use of signs in the town of Bridgton and to promote a healthy business climate while protecting the aesthetic atmosphere of the town in accordance with the town's comprehensive plan, end quote. The mixed-use commercial district allows a variety of uses, which include, and they're quite substantial, I won't go through all of them, but ambulance services, animal shelters, assisted living. You've got bars, banks, hotels, which I will point out moving forward. Your hotels are going to be looking for an internally lit sign. Most hotels are franchised, and as part of their agreement, they have to use the property, such as a McDonald's and a Burger King, whatever they require to document it has to be in compliance with the franchise agreement. So failing that, they will not be able to bring their hotels to the town. The town's comprehensive plan speaks of an area as a commercial hub. There's growing interest to restore Bridgton as the commercial regional hub once again. This trend creates opportunity for Bridgton for development growth, and especially in the downtown and along the corridors. That's a direct quote from your comprehensive plan. And most importantly, the comprehensive plan reads that Route, I'm quoting, 203 from Portland to New Hampshire creates a corridor-like pattern of residents giving way to commercial development, taking advantage of the thousands of cars that travel the corridor daily. The sign fits these objectives. It is unlawful for the town to indiscriminately place restrictions on certain property owners and apply standards that do not exist in the town's regulations. To deny the application for the site plan amendment would be unreasonable and thus unlawful. It would establish poor precedent and send a message to future businesses that they cannot rely on the town's ordinances as written. In sum, the proposed sign is muted in color. It offers a clean, unobtrusive design with minimal lighting. It poses no safety hazards, meets all zoning requirements, and aligns with the purposes and objectives of this town comprehensive plan. With this, the applicant respectfully requests that the planning board approve the site plan amendment for an internally lit sign.
So let me just start for the board here, and you can stay up there.
Yep, thank you.
So just in terms, section V12, amendments to approve site plans. Prior to making any change or revision to a site plan that has been approved by the planning board, the applicant must submit a site plan amendment application to the board, except as provided in subsection B below. Subsection B is exceptions which don't apply in this case. The amendment application is subject to the same review procedures, application submission requirements, review standards, and other provisions of this code as applied to a site plan application. So just so that you have that, before we get to questions and comments, I would like, I don't know if the whole board had seen, and it's not in the OneDrive, the communication between our lawyer and I think the Stark storage owner and Ms. Day. So what I would like is just Ms. Day to give us a brief summary of that regarding the permit, which I'll give the briefest summary is it was the town's analysis that the CEO cannot provide a permit for something that's been conditioned by the planning board. Only the planning board can remove that. So we clearly have a slightly different, or have a different view from what our town has said legally. Ms. Day, could you just come to the mic and clarify that? Just, if I was incorrect in anything that I said.
No, you're not incorrect. Any condition that's set by the planning board, I cannot override. Once it's in the findings of facts as a condition, that is in stone, unless they come back for an amendment.
Okay. And Ms. Day, just while you're up there, my understanding is that the sign was lit internally to begin with.
Yes.
And you had asked that it not be based on the condition.
Yes.
Did we receive any complaints from the public?
Yes, we did. Several.
Okay. Anybody else have questions for Ms. Day?
Was that the sum of what the attorney said, just to set up who could remove the condition? That was the sum of what they said?
We talked a little bit about other things too, because as they stated, that I did issue a permit, but I had conversation with the engineer, because they asked how they remove that condition, and there was a conversation with that, and I told them they had to come back to the planning board to remove a condition, because I couldn't do that. So when I got the permit, just to kind of put this out there, when I got the permit, in good faith, I thought that the permit was what we discussed, and it wasn't. So it did say internally lit, little tiny letters up at the top, and I looked at the size, and I looked at everything else, but thinking that it was, what we discussed and not something other than that. So the attorney said, they would have to come back to the planning board, because I can't override you guys.
Not based on the sign itself, but on the condition and who can remove it.
Correct.
So
Only you guys can remove
Right,
that condition.
okay. And so we're not arguing about literally the composition of the sign, we're arguing about, not arguing, the issue is if the condition can be removed and who can remove it.
Yeah.
Okay, thank you.
I have one more question,
Yeah, sure.
Ms. Day. What was the nature of the complaints you received?
It was extremely bright. I got probably, I'm gonna say 5 complaints that, from people saying it was too bright. Phone calls.
Too bright in that it was distracting or safety issue?
Blinding.
Blinding?
No. Because there was no other lights, like, a couple people had mentioned, like, when you come downtown, there's lights, but they're, it's 25 miles an hour, there's all kinds of, lit signs, so you're not coming up 55 miles an hour, 50 miles an hour, whatever the speed limit is there. With just that one bright light shining, and that was, I think Dan received some complaints as well, so you might want to ask him too.
All right, so,
May I ask just one question
yes, go
very
right ahead,
quickly?
Ms. Miller.
As far as evidence is concerned, the veterinary hospital sign that's here on page 14, am I correct that that was destroyed by a truck and it no longer is there?
No, that's still there.
Or
I
was
don't know,
this-
I don't know that it's lit at
Was this a
night.
replacement for, because there was a sign that a truck.
Yeah, I
hit
think there's a
into.
replacement sign
But
there,
I don't think that this is the replacement sign unless this picture was taken.
but I don't think that it's
It's not.
it's not internally lit,
All right, and one other.
or it's not on at night.
You have other facilities. Is the sign that you are promoting the same sign, intensity, size as that at your other facilities, like the one at the traffic circle?
I am told by the applicant, are you talking about the one in Wyndham? I'm not sure, but yes, he tells me that these, so that is his standard sign, as I said. When they install that sign, there's nothing special about the bulb wattage, it's the same regardless.
But there's more ambient lighting there too.
Well, it sounds like you're gonna have some ambient lighting coming in because you've got that parking lot coming across the street. But if I could just make a point of clarification with regard to the building permit. The permit was submitted as a new sign application, a new sign, not the sign application with you. And that they did not internally light it until the approval came through. And then I'm not sure that people driving by, I don't know what your ordinance is, if they've got a problem, they should come here and talk about it, rather than, we don't have an opportunity to.
Our procedure, so this board can't enforce. Our procedure is that the CEO enforces. So the CEO is typically the person that receives the complaints. We might receive a complaint as such, like Mr. Harden received a complaint, and then he will bring that to the CEO or notify the board, but the CEO really is the person that is charged with that.
I don't know who those people are, so it's difficult to combat whatever they might be saying.
Right, I think some of them wanted to come tonight, so that's unfortunate that, you came up so quickly and unexpectedly. What we may end up doing is allowing those folks to speak once they get here.
Okay.
So in terms of just some comments from the chair for the board, the interpretation of the land use ordinances and the standards in those ordinances and in the sign ordinance when we administrate it, and we do administrate the sign ordinance, those are under our purview. We interpret the standards. We cannot be capricious or arbitrary, and any condition we impose should be related to a standard, and otherwise it would be arbitrary and capricious. So I certainly have some standards in mind that I think need to be adhered to, as well as some information, but I'd like to give the board a chance to go through what their questions are for the applicant. Ms. Miller?
Well, I just wanted to go back to this phrase that you mentioned, lighted in a manner. It doesn't say, this allows for or alludes to various modalities of lighting. It doesn't say any particular manner. It is in a manner And we chose that, and I might mention that at the same time, the application for this facility was discussed with that condition. There was another facility which was not built, but we imposed the same condition in the same stretch of highway, that it be an externally illuminated sign. And also, I would like to say that it's my firm belief that because a sign is legal or acceptable in one part of the town, doesn't necessarily mean that it's acceptable in another part of the town. And the fact that there were two facilities that had, in the same application period of time, that had that condition shows that this was not arbitrarily against your particular application, that it was something that was similarly imposed on a facility in the same stretch of highway.
Okay. So, who else? Mr. Gibbs, do you have something?
Yes, just wanted to mention you use the comprehensive plan, which does indeed try to foster business and commercial development, but it also says in the comprehensive plan that that Bridgton should protect its forests and lakes and maintain its sense of rural character as you enter the town. Is particularly interested in the town entrances and to give the feeling in the town entrances that there is a rural characteristic to Bridgton. So the wooded and not terribly brightly lit areas are a welcoming part of the town. Also in our site plan, it says that any structure should be harmonious with the terrain. And I noticed that you are looking for harmony with structures, but you also have to focus on harmony with the surrounding terrain, which is at that particular side of the road wooded.
Okay, Miss DiPietro?
I was interested in your examples that you brought forth because.
You're going to have to speak up a bit, Kathy. Get that mic closer.
Sorry. Yeah, the examples that you brought forth, I believe the Venezia well predates any sign ordinance that we had adopted at that point. So we may not have had any jurisdiction in that particular area. And I believe the veterinary hospital may be the same situation.
Also, the Big Apple, there are many that predated the sign ordinance.
Oh, Angie, how about you? Questions?
No questions, but I'm just noticing the other businesses in the area are all externally lit from the outside. The
Right.
sports house is, ski hut is.
Yeah.
So, kind of would keep with the area.
Yeah. Dan, how about you?
Not at the moment. I mean, kind of like Angie said, I know one of the businesses happens to be mine right across the street. We do have an external lit sign that has been there for many years. I have the complaints that I received, just so you can have it on your record. When anybody calls me complaining about something, and I brought this up the other night at one of our meetings, my first response to them is always, there's nothing we can enforce as a planning board. We put the conditions in there, we do not enforce them. I refer them back to our code enforcement officer or our town manager if they have a complaint for it. In terms of the sign, when people talk about how bright it was, I noticed all the pictures that you have in here, a lot of nighttime pictures, but the only one that you don't have in here for a nighttime picture is the applicant one. That was on for 2.5 months.
Because we shut it down.
But it was up and running, that they could have taken a picture of it to show the brightness of it.
Right, we were not involved, nor did we come into this matter
Yeah.
until after they had already shut it down.
I can tell you how bright that sign really was, because I happen to own a business across the street. So I know the complaints that came in were, were viable, because of how lit up that area is, when that sign was on. But again, I just told everybody to bring it to either Brenda or to the town manager.
That's fine. If I could respond to a few of these.
Sure.
Okay.
Then we'll get to me.
So, Ms. Miller talks about, and Ms. Cook as well, the way the ordinance is written, it's adjacent properties. So that's going outside the scope of the adjacent property. And you write the ordinance that.
Could you tell me where you are finding that?
Performance standards state that any permanent sign, quote, shall not detract from the design of other surrounding structures and properties and shall be constructed and installed and lighted in a manner not to present potential damage to the value of adjacent properties.
Okay, so that's in the sign ordinance. I don't know if, in addition, Ms. Miller was talking about the site plan ordinance, which does not specify adjacent properties.
But it
So
does
if you allow-
specify terrain at page 8.
Anyway, go ahead.
Yeah, so if you allow an illuminated sign in the district, people assume, and a business comes in here with the understanding that because it is allowed as a matter of right in that district, that it will be allowed. People are looking to rely on that. So if that's not what you're going to do across the board, then perhaps you could add what the illumination should be, a limitation so that people would know what to expect.
That's in the sign ordinance. It can't be more than 0.3 foot candles, and it should be measured when it's turned on,
So that
for
is-
any sign.
So that's actually not a lit sign. I am told by the sign company at that point that illumination, and I believe it's 0.03 as it's stated in there, is actually the sign being turned off. So I'm just explaining that businesses are coming here with certain expectations and the ordinance aren't written that way. And if I could speak to Mr. Gibbs, so Route 302 is a main thoroughfare coming through, so I think we have some conflicting requirements if they want to keep it New England-ish while simultaneously trying to bring in business, because what I read about Route 302 is that they were trying to bring businesses in. So I think we have a little conflict there.
I don't want to get into an argument, but you talk about a permitted sign. We spoke about that. The sign that we permitted was an externally lit sign. That was the sign. And as far as the value of adjacent property, we don't know who might be interested in purchasing or using that property. But it could be that having the internally lit sign would be an encouragement, but it could be a deterrent for the potential abutting properties in coming in. Because looking at the value of the property, which we're trying to assess and maintain, there's an equal possibility that people would look at that sign and say, oh, this is a bright sign that intrudes upon how I may want to use this adjacent property. Or might say, oh, isn't that wonderful? We have this industrial site here with a great, lovely sign. So we can't tell what's going to happen. But what we do know is that in February of 2021, we discussed several applications, and, well, two. And in both of those, we opted for an externally lit sign. And I feel that going ahead and just doing what you wanted to do, or your company, your clients wanted to do, is rather insulting to this board that spent many, many hours discussing the attributes of this part of the highway that we wanted to maintain in a particular way. And zoning in itself isolates certain zones with certain aspects. And therefore, this is really consistent. We don't have to treat 302 in a consistent way.
So-
we can divide it in any way
So I think
our ordinance
we-
includes.
let's-
Thank you.
I know, we're getting on, let's not deliberate
Well,
quite
no,
yet.
I think that.
But I understand what you're saying.
The crux of the matter is, does this board have the ability to make that kind of condition? And I certainly feel that it does.
Okay, thank you. So I have a couple comments. Number one, I guess, I looked at the description of the mixed-use corridor district and the purpose. And although it's not a strict standard, it is an intent. And it says the purpose of the MUC district is to encourage an appropriate mix of low-impact commercial and recreational uses along with continued residential development and to preserve the overall rural and scenic characteristics of the district. So that's something the board can obviously consider in interpreting a standard. In terms of, for me, what I found applied here to this particular sign, although the whole sign ordinance obviously applies. In section 7, design standards for permanent freestanding signs, and I picked out things that are related to lighting and not to size. Item 5, interior illuminated signs shall be designed with timers or sensors to accommodate light intensity to ambient light. Number 6, no sign shall be set with such brightness or intensity that to the average onlooker, neighboring signs will be overpowered or their visibility obscured. The light source, whether internal or external, shall be shielded and shall not create a hazardous glare for pedestrians or motor vehicles and shall not be brighter than 0.3-foot candles. The derivation of that, determination of that 0.3-foot candles was actually an engineering determination based on, that's not the right way, so it was based on engineering information about what was not seen as too bright in terms of, a sign. Then, there's also a section D, there should be an area for planting at the base, minor thing, and then P, which I think the applicant's agent cited, perhaps, maybe not. Permanent outdoor sign advertising a home occupation, business, subdivision, or other commercial activity shall be harmonious with existing buildings and architectural features in the vicinity, shall not detract from the design of other surrounding structures and properties, and shall be constructed, installed, and lighted in a manner not to present potential damage to the value of adjacent properties. So, and then in addition, you have the site plan, section A2, it must meet all ordinances, so that means it has to meet the sign ordinance. And J, advertiser features, which is where the condition was placed on this originally, was on advertising features, and I'll just quickly read that standard. Advertising features, lighted signs and other lighted advertising structures or features must be shielded and non-flashing. Signs and other advertising structures or features must not detract from the design of any proposed structures or surrounding structures and property. In addition, I think one of the things I read from the sign ordinance talks about it not having glare to passing by cars. So I think, one of the pieces of data that I have is what the public commented, and was that when that sign was on, and it was on for a prolonged enough period, it did cause glare and there were issues. So unfortunately, probably some of that public wanted to speak tonight and are not here. So anyway, those are the standards and that we should be looking at for this, in my opinion, the major standards. I will say that if we were to accept a lighted sign, there's no specifications of that sign that tell us how bright it will be. And I don't really accept that because the sign couldn't be turned on, the brightness couldn't be determined, because I think our CEO works with people And if somebody had reached out and said, we want to try something, and even if, then I think she would have given grace for the couple of hours it would take to do that. Unfortunately, that didn't happen because we had to ask that the sign be turned off. I don't see a description of the sign in terms of its lighting, how long it's going to be lit, how bright it's going to be, how long it's going to be on. I note that the facility is open till 11 p.m. So I also note that, at least when I drove, and I've driven several times down that corridor at night, for 9 miles, there was no internally lit sign in that area. There are lit signs, but it is, as it was said originally, a dark corridor. But there are lit signs. Venezia was not lit, maybe because at 10 o'clock they're not open. And it was a similar situation in a shorter distance on the mixed use in the other section, which is more commercial. So I can't really make a determination of whether a lit sign would be too bright with the words de minimis, because it doesn't accurately reflect to me what somebody's going to experience as they drive by, whether it will be glaring or not. So those are my comments without getting into deliberating. Is there any, we haven't called a public hearing, but if there are people here who want to speak, I don't want to keep them from speaking. Mr. Lopez, if you could wait before we go, is it okay with the board if somebody speaks?
Thank you, Madam Chair. My name is Mark Lopez. I'm actually the other applicant Dee spoke of. I had a storage project proposed directly across the street, and we were going through in parallel tracks, the same hearings. When I got my approval, it was contingent upon an externally lit sign. Now, the planning board certainly has the ability to ask for things that are beyond the scope of the ordinance. They can do that all the time in the course of going through the approval process with an applicant. Many times the applicants see that as a way to an expedited approval, and they accept those conditions. Now these guys, this stock outfit, they are experienced developers, okay? They accepted that condition that this board placed after significant commentary by the board, significant commentary from the public. Now, had there been an externally lit sign there may very well have been an appeal. As we know, the abutters weren't afraid to appeal what happened out there. So the fact that these guys accepted that condition, they should have to live with it, okay? If they had an avenue of appeal, if they were aggrieved by that condition, they could have came back to this board and appealed that decision before they started. They didn't do that. They went ahead with their project, they put the sign in, they ignored enforcement orders from the code enforcement officer. The only reason they're here is the Board of Selectmen came to them and said, hey, we're gonna start fining you guys if you don't do what you were supposed to do. I think this request should be given zero consideration. If they don't like, I understand if you don't go forward with this amendment, they have the avenue of appeal, let them appeal it, okay? The abutters that were here that spoke very passionately about not having an internally lit sign, I don't know if any of them are here tonight. They don't have the right to appeal to go back and say, okay, this is not what you guys agreed to. You guys made an agreement with both the applicant and, in my opinion, with the people that spoke at the meeting, that this is how the project will be built. You can't just, as a developer, just arbitrarily change it and say, I don't agree with what you guys decided. My project is built. I'm going to go ahead and just put my internally lit sign in, and then ignore the town has incurred legal fees because of it. And I think it should be given zero consideration.
Thank you.
Thank you.
Don't forget to see if anybody on Zoom. Zoom too.
Is there anybody on the Zoom that wishes to speak? I think they're all here for,
Yeah, I think the other one too, but I just saw a few names
looks
up
like
there.
not.
I can respond to that.
Sure.
And one other comment as well. My client moved forward with the idea that they had this building permit. They weren't trying to circumvent anything. They sent the sign companies put in an application, it was approved, they put the sign up. They didn't put it up beforehand, they didn't light it beforehand. I don't think they were trying to do an end run around. I think that they understood that it was allowed as a matter of right, and they filed the building permit. So I was not privy to everything that took place before my arrival here tonight. So I certainly can only speak to what is presented here. But there's no maliciousness here. I think they're just trying to operate their business, which they need a sign that people can see, and that the clientele can get in there safely and work and use the facility. Because currently people are not seeing it, and I think that there will be an issue out there if the sign's not lit. Thank you.
So just as a way of explanation, I think part of what you're hearing is because there was some email correspondence between the CEO and the applicant about the sign and about the condition. And I think the CEO affirmed at that time, prior to giving the permit, that it had to be an externally lit sign and that the applicant could appeal the decision within a certain amount of time if they wished. And if that time passed, obviously, you're here with the amendment. So, I would just say, given that background, that's sort of the other side of the coin, which is there was discussion about the condition, and unfortunately, the code enforcement officer could not approve an internally lit sign, and as she says, her bad, she didn't realize that's what she was doing. So there's been a couple, we'll just say, mishaps on both sides.
Well, and again, our client relied on that to put that sign in there, which cost them substantial money, and
So-
is continuing to cost them substantial money. I'm here today, so.
Very sad.
So I'd just like to understand that you made a comment that the applicant's not getting customers because people can't see the sign, but it's daytime most of the time, is it not?
Well, their operating hours are until 11 o'clock at night, so people coming in there trying to find that. It is a dark corridor. It's the only light they've got till
It's
that
not
parking
that
lot
dark.
comes across the street. So how else do you see
But there's a
it?
street light right at the corner, is there not?
There
And
is,
if they have
but that's not
externally lit
going to.
sign facing down, could it not be seen? I mean,
They don't have any lighting there currently.
do people go around at
They
night
shut it off.
looking for what storage area they're gonna use? Or are they trying to enter?
I don't
the
have that much
storage
stuff, so I can't speak personally. But if they have operating hours till 11 o'clock, like any other business, you need lighting. If you were a 24-hour gas station, you would want the light to be lit so that the people can see it.
Okay.
If you're a nursing home facility, you need it lit 24/7. There's people
Which
coming in.
fit
Just
with
it's the same as
surrounding
any other
businesses,
business.
too.
Yeah. Go ahead. What did you want to say, Ms. Cook? But not quite. Ms.
Right,
Cook
I
was
know.
starting to say
She's-
something.
I certainly want her to speak. She has a great deal of experience.
Go ahead.
I was just saying that I'm not against it being lit, but if it's gonna be lit, it probably should kind of outfit with the other businesses in the area. The business right across the street is externally lit. The Sports House Caddy Corners is externally lit. So, I mean, if it would kind of conform to the other businesses.
I would just say that the Pleasant Mountain sign, I believe what they committed to was not to light the sign once they were closed. And it wasn't lit last night. So, that's why I asked the question about 11 p.m., because if nobody's entering after 11 p.m., is there really a need for the sign to be on all night long? I mean, if
I
it's
don't disagree.
externally lit.
I don't disagree, but it needs to be lit when people are there, so, that's all.
And I don't think this board is objecting to having the sign lit. So, go ahead, Ms. Moore.
I would like to build on what you're saying. No one is saying that the sign must be dark. It may be lit, but the way we want it to be lit is with an external light shining on it. And it is possible because you see it all over town. So you're arguing that the board is saying it may not be lit. We've never said that.
No, I didn't.
What we're saying is, it may be lit in a manner to fit certain conditions, and we have decided that that manner is to be lit externally. And once again, this company has not been singled out. It has nothing to do with our stance on business, but it has everything to do with what we want our town to look like. And we have the ability to work in the direction that we see fit.
So we have a couple choices here. We can either deliberate now. There's clearly people that wanted to make comments that might be arriving right now or later. We can,
No, that's somebody else.
if 10 people show up, we can call for a public hearing and come back. The other option is, in consideration of the amendment, is to allow the applicant to come back with data that shows exactly what this sign's gonna look like at night. I mean, we have the option of going there for a site walk if we want at 9:30 at night, not very, not the best time, but that's the time you could certainly tell. So, and maybe that's not a bad idea. Ms. Miller?
I don't know why we're taking up all of this time and energy in sidewalks at night. We made a decision, and it is not an illegal decision. The board has the ability to
The
decide.
applicant- So what do you want to do? Just say
I
what you
would
want
like
to
to
do.
dispose of this now.
How about the rest of the board?
I'm okay with going into deliberations now.
Sure.
I mean, we have some of the public comments here. We know what the public comments were before. So,
Agree with Dan. Ken?
Yes, deliberate now.
All right, any other questions about the evidence for the applicant? Oh, wait. I'll just note that, maybe it was an unusual couple of times that I've driven down that road, and also the other part of the mixed-use corridor, but there were no internally lit signs that I saw, and actually some of the externally lit signs were not on. And one of the things we do have to consider is safety. So
Yes.
actually, I forgot about our impact statements. So each of and safety meaning cars coming down the road, and you heard the input of what the public was, that there was too much glare. So it's not just the wooded corridor, but it's safety, and that's in the ordinance. Ms. Day, could you come up before we deliberate on
If I could just make one comment, which goes to your point, the fact that there aren't any internally lit signs there is not a legitimate argument. They're allowed there. The fact that there aren't any there is not a valid argument.
It just makes it it makes it
Women
dark
women wouldn't be voting if we didn't move forward. Women never voted, now we vote.
I
If there's no
understand what
externally
you're
lit
saying.
sign, then
Oh, wow.
I understand what you're saying.
we need to
Ms.
make some
Day,
progress.
Could you, thank you. And the chief may want to comment since he's here. So, all of the impact statements basically said, recommended the board keep the original approval, or in one case, if internally lit, it must be dim.
Correct.
And I think that was the policeman, so I
Yes.
assume he was thinking about traffic. And then one other was, is there some in between? So can you just, because you're the the person that runs these department head meetings?
I think most of us agreed to keep it as the planning board approved. Like you said, the police chief did say, you know, if the board was to vote on having it internally lit, that he would be okay with that, but it would have to be dim. Yeah.
I have another question. There's other lighting at the storage unit, right, down
Yes.
the aisles? So the only light provided is not gonna come from the sign. Matter of fact, if the sign is lit, it's not gonna provide any light to the people in the storage units because it's that far away from them. And it's 3 candlesticks.
They have to see the driveway to get into the storage facility, because the units are far back.
Yeah, so we had Chief Garland, he support the external lit sign. Myself and the community development director and Phil Jones did either switch to the externally lit or adjust the brightness.
Any other questions for the applicant? Anybody need any other evidence? All right, so I'd suggest that we deliberate. Do you have anything else you would like to offer?
No, I just appreciate your time and attention, and, he's trying to comply, not to be a good businessman here.
Okay.
Just would like to keep a sign that he paid a lot of money for.
Oh, he didn't have to pay the money.
D. So, we are supposed to go over every standard, so we should do that, but obviously a lot of these are the same since we're talking about a lit sign. So we'll start with, I propose that we don't, unless somebody's seen something that's unusual, we don't need to go over the land use standards because that deals with dimensional standards and there's nothing changing here. So in terms of the general criteria, it's an allowed use. It says number 2, the proposal complies with all other applicable requirements of this code and the town's ordinances, rules, and regulations. I think we'll go to the sign ordinance after this. And it's consistent with the comprehensive plan. Any comments on that? Okay. Preservation and enhancement of the landscape.
So could we bring up stuff that was promised in the original application that hasn't been done?
Yeah.
Or are we only talking about the sign?
Well, that's a very good question, Mr. Harden, one I thought about myself.
Yeah.
May I suggest that
I
that
would
speaks to
say
the good
that-
faith of the applicant, that they didn't do other things that were required?
What I would say is I think that's an enforcement issue, but I would say that it's okay to bring that up at the end. I don't know that I would deliberate on that
Okay.
item. I would say that because the sign ordinance talks about landscaping around the sign, that's certainly valid. And I don't know that the original plan had, I can go to the original plan right now very quickly.
Because the reason I bring it up is there were 2 things. One was the landscaping and one was the architectural structure of the building that isn't what was originally submitted to us.
Meaning the cupolas?
Yep.
Yeah. So I think if the applicant doesn't want to put cupolas on, they need to come for an amendment.
Yep.
That's what I would say. And if the landscaping is different than what was described, they should they should put that in the same amendment. And if the lighting on the storage areas is not residential type down lighting, they should also put that in the amendment. That was another comment I had. Just let's quickly, sorry to take this much, but let's go to the original Stark storage.
That's in prior applications, right?
Yeah.
In 22?
Yeah. So we
No,
had
it's 20
requested additional landscaping, but I don't know, it's in 21, I'm sorry, Dan, 21, 2021.
There was a lengthy discussion about that.
I don't believe there was any landscaping, oh, wait a minute, here we go, the final landscaping that was agreed. Yes, there was landscaping that was, from what I can see, I'll just throw this over to the board and to the applicant. There is landscaping, this is the sign, I assume. And so those are all little bushes that go around the sign. And those, I think that doesn't say what those are, but they were supposed to be, like shrubbery essentially. So, I say it's probably fair game, when we get to the landscape section of the land use code, which is the one thing we'll get to the form codes. Bring that up then. Okay, relationship to surroundings. This is talking about structures or additions to existing structures. Any comment? Vehicular and pedestrian traffic. Traffic circulation.
May I just wanted to say, if one of the arguments is that people can't find the driveway, installation of reflectors or other external lights to mark the driveway could be added to an amendment.
But it's not
I
in
would
the
mention
sign.
that the original, when the board specified an externally lit sign, they recommended to the applicant that they could have a sign, it could be lit from above pointing down, as many of the signs are that are externally lit, so that you wouldn't have maintenance issues with snow and everything with it pointing up, as well as, the dark sky issue. Okay. Traffic circulation, parking, surface water drainage, impervious surfaces, public utilities, none of those are affected. If you disagree, say something. Advertising features, lighted signs and other lighted advertising structures or features must be shielded and non-flashing. Signs and other advertising structures or features must not detract from the design of any proposed structures or surrounding structures and properties. What's the board say?
Read that again for me.
This is where we applied the condition before. Lighted signs and other lighted advertising structures or features must be shielded and non-flashing. Signs and other advertising structures or features must not detract from the design of any proposed structures or surrounding structures and properties.
Yeah, I mean, I can say personally, seeing that sign at night, it is not shielded, it is blinding, it does definitely come across the roadway, down parts of Mountain Road. When you talk about, there's an empty field across the street, that's a great example. There's an empty field across the street that goes right up to a wood line to the backs of some of the people's houses. So, I mean, that sign is, the way it was originally on was very, very blinding at night. I have photos. I don't know if we submitted those as evidence. When Brenda,
I think you passed those to Brenda.
I believe, did I get those ones to you, Brenda? Because there was question whether or not the sign was on at night during that period of time.
You showed them to me, but I don't think you ever sent them.
Okay. That show you how bright the area is at 11, 12, 1, 2 in the morning. So that I would still put the condition in there that it's an externally lit sign. I heard the applicant say that, there's a lot of maintenance issues with them, the lights don't last as long. I have externally lit signs on my own business, across the street that have been up for the better part of 4 years. I have not changed the bulbs once because they're LED. They're on dimmers, and in one of the pictures that you submitted, showed my original sign with the lights that were down on the ground coming up. Yeah, those were a royal pain in the wintertime. That's why we switched to the upper downward lighting when we redid our sign.
And when was that, Dan?
When we redid our sign?
Yeah.
It's when Ski Hot first went in, so I want to say 4 years ago, 5 years ago. I don't remember the exact date. I'm sure Brenda could pull it up somewhere in the files. But we put those signs, those lights in, and they've been that way now, like I said, for the better part of 5 years, and I haven't changed one bulb yet. I believe they're 100,000 hours. But they're not on all the time. They're on timers.
So you have them on a timer then?
Yeah. I will say, if you do go up right now and look at it, my timer got fried on the wall inside the office because of a power outage 2 days ago. So they are staying on a little longer than they should be right now. But that's not any condition on me, but that's just, I'm waiting for a part to come in. But they work perfectly fine as downward lighting.
Does anybody else have any comments about advertising features? I can't add much to what I think that's one of the major issues, in addition to maintaining the intent of the mixed-use corridor district, is the brightness and the glare, which it shouldn't be that way. Okay, special features of the development. Did you have a comment, Mr. Gibbs?
No, did it fail this standard? Does the amendment fail by this standard?
Well, I would say if it's not this standard, then it's the standard in the sign ordinance,
Yeah.
which I'll just go to that.
Yeah, because if they fail one standard, then it fails.
Right. So in the sign ordinance for we're going to go piece by piece through the sign ordinance, but I'll go to the design standards for permanent freestanding signs. The design of lighting of signs and other advertising structures shall be shielded and non-flashing. So Mr. Harden says his observation is it wasn't shielded. And not detract from the design of surrounding structures and properties. Within the downtown village district, the sign, if illuminated, shall be illuminated externally. Outside the downtown village district, the sign may be internally illuminated. There shall be no more than one sign per lot. I don't think we have a problem there. Interior illuminated signs shall be designed with timers or sensors to accommodate light intensity to ambient light. I saw nothing in the application that said that that would be done and that that standard was met. Mr. Gibbs?
Just the language using may is a permissive language, which
Right.
means that it can be internally illuminated by permission.
But there has been
No sign shall be set
there's
with
no
such
permission
brightness or intensity that to the average onlooker, neighboring signs will be overpowered or their visibility obscured. The light source, whether internal or external, shall be shielded and shall not create a hazardous glare for pedestrians or motor vehicles, and shall not be brighter than 0.3 foot candles. Sign shall not be animated, flash, or scroll. If any part of the sign is malfunctioning, the sign must be turned off. Mr. Harden. And the rest of those have to do with size. Except freestanding signs shall have an area at the base for planting of shrubbery or other landscape materials, or directly in the soil or in planters or other appropriate containers. So what I would say is the applicant did propose shrubbery around that originally, and I think that that's an enforcement issue for the code officer to check on. Does that make sense, Ms.
I
Day?
think I already checked on the plans.
Okay.
I think they were all good. They're really small.
Okay.
There's, the bushes are kind of behind, but they're all there. They're just really low right now.
Hopefully they'll grow.
Right.
Okay.
With all this rain.
Yeah, and I think that's something we as a board have to.
Pay more
kinda
attention
Pay
to.
more attention to of, you know, when you call it a naturally wooded buffer, make it look like a naturally wooded buffer. And there's like 3 Charlie Brown trees, that's not natural. But again, we did agree to, I believe it was like 3 or 5 maple trees and some understory stuff, but we didn't specify size.
I believe those are all the ones that apply, other than electric wiring used to illuminate. Yeah. So there's a couple of grasses under there.
Yeah, there's about 3 or 4 of them by the looks of this sign, because this is the one for
Yeah,
that
so
particular
we should pay more
facility.
attention to that in the future.
Yeah.
May I make a comment about D? No sign shall be lit so that its beams are raised or directed at any portion of a public street or highway.
D you're looking at?
Yes, on page
Are you on the sign ordinance?
4, sign ordinance.
Oh, okay,
yes.
you're
Yeah.
prior to that. Thank
And
you.
in reference to the police chief's comment, even accepting an internally lit sign, as it existed when it was lit, he indicated that he thought it was too bright. And Ms. Hill felt the same way. So any comments dealing with an internally lit sign was that the sign that is or was lit when it was lit was too bright.
Okay. So, I'm sorry to jump around a little bit, but I think on advertising features, I'd like the board to weigh in on, well, it's hard to know, but I'd like the board to weigh in on whether an internally lit sign meets advertising features J, and then we'll go to the sign ordinance and go through it specifically. I think if it's not, I think we don't have any evidence that it would be shielded. And we do have evidence, although we do have a public comment that it was glaring, and in fact, I believe, did light the whole field up so that it went across to the Alpine Road folks. So, does the board want to vote on that now? Or you want to come back when we're all done?
But whether it meets the standard.
Right.
Yes.
I'd like to move that it does not meet the standard.
Okay, I think that's,
Of
so we will
advertising.
vote yes if we're supporting that. Is there a second on Dee's motion? Second by Mr. Harden. Any further discussion?
Is Ms. DePietro?
Ms.
voting?
DiPietro is
Yes.
voting. All in favor, raise your hand. All opposed? Okay. Let's go on. We will go back to the sign ordinance specifically. Let's get done with site plan. We were on exterior lighting. All exterior lighting must be shielded, non-flashing, and energy efficient, and must be designed to ensure safe movement of people and vehicles. Lighting must be located so as to minimize glare and reflection on adjacent properties and roads. I think this is kind of related to the one, to advertising features, although I think it's talking about lighting on buildings.
Well, I'd like to move that it does not meet that standard.
Because of the sign itself?
And the lighting and
And the lighting on
adjacent
the building.
areas.
Well, what's the issue with the lighting on the buildings? Which wasn't submitted.
No, you said on the buildings. I was
You're
referring
talking about the,
lighting spilling over into other areas.
okay,
That you did, I think is part of the same standard.
okay, well, it can be. All right, so why don't you move that, Ms. Miller,
I move it does not meet the standard.
for L, exterior?
Yes.
L, exterior lighting. Is there a second? Second by Mr. Harden. Any further discussion? I would just say in writing the findings that it says all exterior lighting and an internally lit sign is exterior lighting. And it specifically calls out safe movement of people and vehicles. I think it could be externally lit, and there could be safe movement of vehicles to see the driveway, especially since there's a street light at the corner. But you don't want people driving by to be blinded either. Okay, emergency vehicle access. I don't think there's anything. Mister, you got anything? No? Okay. Municipal services. Water quality. Say groundwater, air quality, water supply, soils and erosion control, sewage disposal. None of those would apply in this particular case. Scenic impacts proposal must not alone or in conjunction with existing structures have an unreasonable adverse effect on the scenic or natural beauty of the town, including the aesthetics, historic sites, rare and irreplaceable natural areas. I think this normally is being applied to the structures themselves and the actual use and not the lighting. Noise. Location applied by technical and financial capacity. Special regulations. There is no outdoor storage of anything. Road design does not apply. So let's go now to the land use ordinance, just to the district space and bulk standards. I would make one more comment. Nobody's arguing that the use is not appropriate in that district. It's the signage. Okay. So this is the mixed-use district. Setback requirements, facade building projection, street wall, none of those are regulated. Garage and parking. That was met in the original application. It's not a corner lot. Landscaping in conjunction with project development. I think we did accept the landscaping. It's really up to the CEO to determine whether it meets that. Sidewalks, not regulated. So now let's go to sign ordinance. That's okay with everybody? And we'll go a little bit piece by piece here.
Slipping around like crazy here.
Did you find it? Everybody find it?
Yeah. We have PB ordinance is number 4.
So the purpose of the ordinance is encourage the effective and safe use of signs in the town of Bridgton and to promote a healthy business climate while protecting the aesthetic atmosphere of the town in accordance with the other town's comprehensive plan. And then it talks about what it wants to do: promote safety, comfort, well-being, reduce distractions and obstructions from signs which would adversely affect traffic, ensure that the signs provide effective orientation, preserve and enhance the visual appearance of the town pursuant to the comprehensive plan of the town. And it's administered by the board and enforced by the town manager. And then it tells you what it applies to, and it applies to this, then it goes into enforcement. So general regulations, and so these regulations are really the interpretation of the intents. Number 1, no sign except for municipal signs may be erected, installed, or displayed within 10 feet of any park. No problem there. No sign should be erected at any location by position, shape, wording, or color interferes with or obstructs the view of travel or pedestrian, vehicular traffic. Shape, wording, or color. So I think that's okay.
Well, except
Well,
that the
except for the
police
traffic part.
chief did specify.
Well, it says, I think that's in a different standard.
Okay, fine.
I'll put an X next to that, but I think that's in a different standard. I think this is talking, it says by reason of position, shape, wording, or color.
All right, but it is a bright white sign. And
Yeah.
bright white is the most
When it-
disturbing.
When it's, yes, but
Yeah,
when it's
during the
lit.
daytime, it's not.
No,
Yeah,
but,
I think
but
you're right.
when lit at night.
It goes to the other one.
Okay. It can't be confused with authorized traffic sign. No sign shall consist of pennants, ribbons, streamers, sheets, spanners, not spanners, spinners. I think we have enough evidence to say it's okay there. Consist of strings of lights, blinking, flashing, or fluttering lights, or other illuminating devices which are glaring or have a changing light intensity, brightness, or color illuminated by other than steady light. I think if it were internally lit, it's steady light, except that the brightness per our ordinance should be adjusted to ambient light and should not be glaring. So I think it's okay there. Be painted, placed, or constructed on a roof, movable or portable unless it's temporary, emits sounds. No sign shall be lit so that its beams or rays are directed at any portion of a public street or highway when the light is of such brilliance and so positioned as to blind or otherwise impair the vision of the driver of any motor vehicle. I think both Mr. Harden and Ms. Miller commented on this.
Yeah.
Do we want to vote on this? Because I think you, Ms. Miller,
I move that it does not meet the standard.
is there a second? Second by Mr. Harden. Any discussion? All in favor, please raise your hand. 5-0. So that's D. Next one, E, doesn't apply. That's removal of signs. Change in size, construction, or location does not apply. Signs with changeable lighting or messages may cycle, change no less than every 10 seconds. It doesn't apply, they haven't asked for a changeable sign. Portable signs are considered temporary signs, it's not a portable sign. All lighted signs and message boards shall use manual, electronic, or photocell technology, shall conform to the lighting standards contained in this ordinance, regardless of time of installation. I don't think that it meets the lighting standard
The .3
in section 7. So I move that item I fails the standard, or item I does not pass. Is there a second? Second by Mr. Harden. Any further discussion? All in favor, please raise your hand. 5-0. All newly permitted EMCs shall be equipped with a sensor or other device that automatically determines the ambient illumination and that is programmed for adjusted to dim to ambient light conditions, or that can be adjusted to comply with the 0.3-foot candle measurements. I would submit, because we don't really have any evidence of whether it's EMC internally lit or otherwise. If that evidence wasn't turned in, I don't think it meets the standard. So I move that it does not meet standard J due to lack of evidence.
Second.
Seconded by Ms. Miller. Any discussion? All in favor, please raise your hand. 5-0. Then it goes into the approval process. And it says, no agency, firm, developer, or corporation shall erect a sign or sign structure covered by this ordinance without approval from the code enforcement officer or planning board. In the case of this, the planning board had the reviewing authority. Okay, section 7, design standards for permanent freestanding signs. Shielded and non-flashing and shall not detract from the design of surrounding structures and properties. Again, we have no evidence that it's shielded and it was observed not to be shielded. So again, a motion for that. Moved by Mr. Harden that it does not meet standard number 1 in section 7. Is there a second? Second by Ms. Miller. All in favor, please raise your hand. 5-0. It's not in the downtown village district. It is outside the downtown village district, and it says the sign may be internally illuminated, meaning the applicant could internally illuminate it. I think this board is going in the direction of having it internally illuminated conflicts with other standards. 1 sign per lot. Interior and 2 illuminated signs shall be designed with timers or sensors to accommodate the light intensity to ambient light. I move that it does not meet this standard because we did not get any evidence that it meets this standard. Is there a second? Second by Mr. Harden. Any discussion? All in favor, please raise your hand. Angie, you up or down? Okay. 6, no sign shall be set with such brightness or intensity that to the average onlooker, neighboring signs will be overpowered or their visibility obscured. The light source, whether internal or external, shall be shielded, shall not create a hazardous glare for pedestrians or motor vehicles, shall not be brighter than 0.3-foot candles. We don't have any evidence that supports that. We have some evidence by way of abutters and Mr. Harden's testimony that it was glaring. And obviously, the police chief commented that if it could be made not to be bright or could be dim enough that it would be okay, but we don't have that evidence. Ms. Miller?
This is really an amendment, and so it should have obviously been an application to install an interior lit
Correct.
sign. And if it were such an application, all of these issues should have been part of this new application for an amendment. And none of these regulations or standards were presented as evidence.
I agree. That was, when I said at the beginning, I had some items that I felt were missing. These were the items. So we should vote on number 6 as well. So I make a motion that item 7.6 does not pass the standard due to lack of evidence, and also because the evidence we have from the public does indicate there was hazardous glare when it was on.
7 or 6?
Second.
You said
6.
6.
Section
You
7,
said
number 6.
When you motioned, you said motion 7.6.
No. Section 7,
Okay.
number 6.
All right.
So
I'll
I
second
move
it.
that, second by Mr. Harden. Any further discussion? All in favor, please raise your hand. Signs shall not be animated, flash, or scroll. That wasn't in there, but I don't believe that was the intent.
No.
If any part of the sign is malfunctioning, the sign must be turned off. We can't rule on that. B has to do with its size. It's not a reader-borne sign for C. D, freestanding signs should have the shrubbery. We talked about that. In multiple tenant or non-residential buildings that have 2 or more tenants, there are no tenants. Town of Bridgton is not responsible for allocating amounts of allowable sign area. That doesn't apply. 10% of the wall area of a building, that doesn't apply. No more than 2 individual signs advertising project, they're only asking for 1. Signs on perimeter fences not to exceed 10%, they're not asking for that. It's not a multifamily residential development. It's not installed on a building facade. The wiring should be enclosed or buried underground, which I assume that it is. Awnings, marquee signs, or patio umbrellas, it's none of those. Other sign requests, standards, and considerations will be entertained by the planning board on a case-by-case basis. I guess that's what we're doing. All signs shall conform to the laws of the state of Maine. Any permanent outdoor sign advertising home occupation, business, subdivision, or other commercial activity shall be harmonious with existing buildings and architectural features in the vicinity, and shall not detract from the design of other surrounding structures and properties, and shall be constructed, installed, and lighted in a manner not to present potential damage to the value of adjacent properties. We did discuss that at length, and the applicant also presented their evidence on that. Does people have any comment on that?
I would say it's not met based on what you just read.
And what part of that? I think when I look at it,
That it won't distract from surrounding properties.
I think there is a home that's adjoins that area. Yes, they're set back, and there's homes across the field. And unfortunately, the only evidence that we do have is that when the sign was turned on, it was glaringly bright. So it did detract. And I do believe some of the people that commented were from the Alpine Road.
Yep.
But what I might want, Brenda, we should have a record of that somewhere. I don't know. Well, you know what, we can only use what you testified to, so. Do you know if any of those people were from the Alpine Road subdivision?
From the comments from yesterday,
Yeah,
one of them definitely lives in Alpine Village, the other one lives down
okay,
on Mountain Road, but not in that village.
okay. So I'll move that item P is not met. Is there a second? Second by Mr. Harden. Any further discussion? All in favor, please raise your hand. 5-0. The next section does not apply. And the next section, at this point, does not apply. And I would read the definition of glaring illumination, maybe we should do that, and ambient lighting, to make sure we don't change our minds about something. Ambient lighting, the light available without additional flash or reflectors. Ambient light can be of natural or artificial origins, such as room lights or lamps, or of natural origins, such as sunlight. It describes foot candle, so there's a definition for that I won't read. Glaring illumination, light of such brilliance and so positioned as to temporarily blind or impair one's vision or affect the aesthetic value of surrounding structures or property. So, does anybody feel they need to reconsider anything after I've read that? Okay. Then I think we're done. It's not in the shoreline zone. We have to move based on what we've done to deny the application, so I need a motion to deny the application. Moved by Mr. Harden, of course pending findings of fact and conclusion of law, seconded by Ms. Cook. Is there any further discussion?
Is it an amendment or is it an application?
It's the amended application, but it's an application for an
To
amendment.
amend.
But thank you for the clarification. Further discussion? All in favor, please raise your hands. 5-0, the application is denied. I will write up the findings of fact with Laura Lee, and the board will have those for the August meeting, and they will share them with the applicant, and obviously with you. And I think that's it for now. I appreciate your time.
Yeah.
Yeah.
Just in case there's people sitting here for it that came in later.
Yeah, so, for the if there are folks here that are here for Voodoo Holdings, Mr. Voodoo did not appear, and we cannot continue to review the application without him being here. So, therefore, you can leave if you don't want to stay and listen to everything else that's going on. But we won't hear that tonight. I don't think we'd hear it even if you came in at this point.
No.
This is window of opportunity.
Yep.
Okay. Next on the agenda is the Sweden Millbrook subdivision?
Nope.
No?
Nuria Energy Amendment.
Oh, I'm sorry. Next on the agenda is the Nuria, my notes are so small, Energy Amendment. The applicant's agent is here. Is there anybody that wishes to recuse themselves from this? Okay. There's proper standing, proper notice has been given. Do we feel the amendment application is substantially complete? Okay. Do we feel we need a public hearing or a site walk?
No.
Okay. All right, and if you could introduce yourself, and
Hi.
that you're obviously representing Noria.
Yeah, good evening, Norm Chamberlain, Will Walsh Engineering. We got approval on this, I think, last summer. And since that time, we've been working on architectural drawings, and they would like to change the look of the building slightly. So what I've got here is the proposed building and canopy on the top, and then that's what the board approved last summer on the bottom. So it's basically a change in roof lines and materials. They're going from an asphalt shingle roof to the standing seam metal on both.
So the top is the new design,
The top is the new design.
and the bottom is the old design?
Correct.
Okay. And those drawings are in our packets, but they're substantially smaller. I have one question for you before you go too much further. I noticed in the drawings that the interior was also changed from what I could see, because you have a basement drawing that you didn't have before.
I just found out that we're not doing the basement.
Oh, you did?
So, yeah. So that was one of the questions we had before the board was, they were planning to add a basement, but now it's been taken out as they refine these drawings and, look at the store.
Okay, so the interior is,
Yeah, the only change really was just to provide a space for mechanical equipment and storage. That's what the basement was for. So the layout of the store, the size is the same, the canopy is the same size. The site plan didn't change at all, that's why I didn't
okay.
resubmit
So
that.
we should disregard that drawing we got showing the basement?
Yes.
Yes.
Okay, thank you. Okay,
So really, it's changing it to, if I read the architect's notes here, to add gables with a louver at each end of the building to enhance the traditional New England style of the store. The roof height is the same. As I said, the roof material is going from asphalt shingles to standing seam metal roof. The fueling canopies have been revised to simple hip roofs with the gable removed, and materials are standing seam. And the fueling canopy fascias have been increased from 2 feet to 3 feet in height. Page 34. That is, this part here is a foot taller than it is now. But they've removed the gable, so I think it,
what was the rationale for removing the gables?
I think it's a style issue. This is Pat McLaughlin from Nuria.
Yeah, good evening, Pat McLaughlin with Nuria Energy. Thank you for your time. Yeah, so this is kind of like a mass balancing exercise. So I'll start by saying we've been through a few other communities in other New England states since my counterparts were here last summer in front of this board. And through other feedback that we've gotten in a lot of collaborative design processes, we really have come a long way with our building design from where we were last summer, and got a lot of good design ideas that we feel happy with, including the standing seam metal, which we feel is very New England. As I drove through town for the first time, being in this area, it definitely seems like it fits. Eliminating the gables, adding the gables, which extends the roof line of the convenience store building, provides, I guess, more prowess to the store and then taking them off of the canopy minimizes the canopy, which we feel is the right ratio. I think you want to attract the site to the store and away from the canopy. We've seen, not only in our own experiences, I guess, but also, you drive around, you see gas stations and you see what, other competitors are doing. And when you add the gables on the canopy, that becomes the massive, the bigger structure almost, because it's in the foreground, closer
Yeah.
to the traffic. So that's kind of the thought process on the massing exercise there. So we hope you support us with it.
Okay, any questions from the board? Dan?
On the redesign, standing seam on the main building, are you doing the standing seam on the
Canopy
as well? Okay.
Yes.
I thought I heard that, I just wanted to make sure.
Other questions? Anything else you want to let us know about the project?
We're anxious to get started, so, we shortly after a hopeful approval this evening, we'll be filing for a building
Okay.
permit review, so, but we didn't want to do that, not knowing which
Right.
style roof we were gonna file for.
Is the board ready to deliberate?
Yeah.
I am. Okay,
I'm good.
so let's just go straight to the site plan. And I think this is fairly straightforward, so. Alrighty. General criteria, it complies with the comprehensive plan as it did originally. Complies with the requirements of the code, we'll go through that. And it is allowed it's allowed in the town, in the use. Preservation and enhancement of the landscape, I don't think that applies to this amendment. Relationship to surroundings, I think this was the majority of the discussion when it was designed to begin with. Be compatible scale and size, compatible architectural style, integral element of design, varying roof lines, etc., awnings, exterior wood, stone, brick, or other material having same architectural and visual properties, avoid, minimize disruption. My comment is, I think this design is improved over the first design. The black roof, I particularly like the way the store has been set off with the insets there and it coming out.
It's a dark bronze, just so you know.
Oh, dark what?
Bronze, so.
Dark bronze, okay. It looks good up there. All right. Does anybody have any comments? No? Vehicular and pedestrian traffic, I don't think that changes. Traffic circulation does not change. The size of the canopy, the size, the driving aisles, it's only the top that's changing, right?
That's it.
Okay.
Actually, I think one thing that, let me just fact check myself. One thing that we learned on these canopies, and I'm gonna come out with it. What you're seeing here is there's actually a single structural column on this. And I think this has even been, since this plan was drafted or submitted, so 6/22, and maybe just write this in. Structurally, what we found was, we used to do a single column which was behind the dispenser, so that the dispenser was more, towards the road, it was more visible. But we found that once you go with any type of roof structure over the top, that one, it's easier structurally with steel to support that all with two columns. You can do it with one, but you end up paying for, heavier steel for more of a cantilevered structural design. But two, just aesthetically, again, with the balancing of all the massing, this will look more appropriate with two columns, so the one on either side of this dispenser. This does not show that. I'm just catching that live as we talk about it, but we can certainly make sure that you understand what that looks like as we because structurally we'll file for that when we file for a building permit.
Are we,
I think
is the
that's
board
fine.
okay with that?
Yeah.
So I'd say just turn that, get us the follow-up on that.
Yep.
Is that on all corners?
It's on each column line
Right,
of the
okay.
canopy. It is such that way on the diesel canopy, and I believe always was, because those diesel canopies are deeper front to back. So in this case, yeah, there'll be two here. I definitely have examples of what that looks like, but.
Yeah, I just say, we'll write in the findings that, we'll just, unless you have it, like in another month, we'll write in the findings that you'll submit the final drawings prior to any permitting by the CEO.
Yeah.
But, you know, even better is if you have them before we get to sign those off.
Yeah, sure.
All right? Surface water drainage. It seems minor enough change, it's not gonna impact anything. Impervious surfaces, there's no change there. Public utilities, advertising features, special features of development, exterior lighting, emergency vehicle access, municipal services, there's no changes proposed to any of those, or there's no changes proposed that would affect any of those. Water quality, groundwater quality, air quality, water supply, soil and erosion control, sewage disposal, scenic impacts, noise, location and floodplain, adequate technical and financial capacity, special regulations. Any comments on any of those? Okay. And in terms of the shoreline zone, it's not in the shoreline zone. In terms of the land use requirements, doesn't change from what they've just told us, any of the dimensional requirements. And just to double check it's obviously an allowed use. And just to double check the district standards, space and bulk standards. This is in the outer quarter. Doesn't have a front setback area requirement. Facade is not regulated, street wall not regulated. Garage and parking has already been approved, is not changing. Not a corner lot. Landscaping has already been approved. I think that's everything. Ms. Miller?
I just have a question. I mean, essentially what you're talking about is a design change for the structure. And you said you've worked with other communities. Is this going to be then your, let's say, your standard structure in all of your locations?
Well, it'll probably be one of two. So we have something that we use down in areas outside of Boston, which is more of a flat roof. I wasn't involved the first time around, so I don't even know if you guys saw that version.
We did.
We saw the flat roof, we didn't like it.
Yeah, understood. And again, there's a we have that feedback from a lot of communities. What we realized was, then you get into discussion in one town, then, you build based on those comments, you go to the next town, you say, okay, that was our starting point, you do a little bit more. So we kind of looked at it and we said, we've got something that really is a version B that has come together through all the various New England architecture schemes that we've heard, and let's try and make that harmonious, because there's been a lot of good feedback that's similar throughout the more rural towns that we've been going to.
I'd like to commend you for listening.
Thank you, yeah.
So I accept a motion to tentatively approve this with the condition that the applicant will turn in the final design for the canopy prior to any permitting. Moved by Mr. Harden, is there a second? Second by Ms. Cook. Any further discussion? All in favor, please raise your hand. 5-0, thank you.
Thank you very much.
So we've changed the way you look.
That's right.
Nice to have an easy one.
You have a plan B?
5-minute break.
Yeah. Mr. Harden has asked if we could take a 5-minute break, so let's do exactly 5 minutes. Millbrook subdivision, Sweden Road, map 13, lot 81A and 82. This is for a subdivision. Is there anyone that wishes to recuse themselves? Mr. Gibbs?
Yes, I would like to recuse myself and sit with the abutters and be able to speak as a resident of
Okay.
of Millbrook, and ask that the chair give permission for the abutters to speak.
Okay, but we'll get to whether we'll do a public hearing or we'll do it the other way. So
Okay.
you get to go to the audience.
Okay, here he goes.
You want some music?
And Kathy will
Traveling music.
continue to be the voting member. The applicant has standing, proper notices were given. Do we feel we want a public hearing or a site walk? Are the people in here, are you here for this subdivision? Can you, all of you? Okay, no,
Not all.
they're not. They're just there. Okay. So my question to the board is, do you feel we should have a public hearing given the public interest, which is 3 or 4?
Yeah, Madam Chair, I would like the board to maybe talk about, listen to the presentation from Mr. Seymour, and then make that decision. This is an application that conforms to all the components of the election.
Does the board have an issue with waiting on that? Same for the site walk? Let the applicant give the overview and then make a determination of whether we want a public hearing?
Yeah, this conforms to all the elements of the land use ordinance.
Ms. Miller?
I'm sure it does conform because this applicant has been here many times. And I think it might be helpful to listen to the nature of some of the abutters, and then we can decide if that goes to the level where we would want to do more by having a site walk.
Yeah.
Site walk or a hearing?
I have no issue with that, Madam Chair. No
Okay.
issue with that.
So let's do that. So just remind the board that first of all, we should allow Mr. Seymour, is that correct?
That's correct.
And to give us the overview. And then I think after the overview, if somebody thinks we should have a public hearing, you should raise it then. And if you don't raise it then, we'll allow the audience to speak and then make a decision whether to have a hearing or a site walk. Okay, does that make sense? That's a good suggestion. Floor is yours, name and...
Thank you, board members. My name is Jim Seymour. I'm a civil engineer with Sebago Technics. I'm here with Mr. Lopez of ML Investments for this 5-lot subdivision located, as you mentioned, between Sweden Road and Millbrook Road. The property consists of 6.3 acres. It's located in the Lakeside Neighborhood District. Under the subdivision requirements, that minimal lot size is 40,000 square feet with 100 feet of frontage. 2 of the lots will front on Sweden Road, 3 lots will front on Millbrook Road. There will be no internal road. There's one shared driveway between Lot 1 and 2, which is located on Millbrook. The other Lot 3, where you see the dark patch, which will be a fire relay station, will have one driveway. The 2 lots on Sweden Road will each have individual driveways. As noted, this is located in the Highland Lake Water District. With that, we have provided the board with phosphorus calculations, and to meet that standard, each lot within the subdivision will have a 100-foot buffer down gradient of their home location. The lots have been provided with test pit data to provide passing soils for septic systems. With that, we requested a waiver of the HHE 200 because although we have shown the location of the passing test pit, that often changes with the exact home location by the provided homeowner at the time of building permit. That also included hydrogeologic assessment. As I noted in my cover letter to you, this site drains all the way from Sweden Road straight down to Millbrook. With those septic designs, that whole nitrate plume will go straight through all the properties, and where it's located so far back off Millbrook, it will not have an impact on any abutter or public road.
So far back up Millbrook, what do you mean?
Off of Millbrook, it'll be, messed up with here.
We can't see it from here.
it'll be the septic systems are the
Would you
closest
stand
septic
on the other side, please?
Yeah, we can't see the.
Thank you. Thank you.
Like
How about closer still?
Can you see
It's
it?
like Fenway Park, there's a post right where you don't want it. So the closest septic systems would be here to Millbrook, which is more than 200 feet from Millbrook Road itself. The other septic systems are way up here, all this drains in this direction towards Millbrook. So those septic systems are located way back here with the building envelope. There'll be a substantial, at least 100-foot buffer. You're looking at 250 feet most likely from the edge of the right-of-way to where the closest septic system would be.
So could you just repeat the distance for each of those lots to the septic system? Or proposed septic system?
So if you look, each one of these has a test pit symbol. The closest one is 250 feet from Millbrook in this direction.
Yep.
These are located up in the middle of the lot, and they all drain in this direction, so they're several hundred feet away from Millbrook. And all these drain in this direction. They do not roll off the abutters, they come straight down the hill.
Okay.
So we feel this is a pretty simplistic application, given that there's no internal road. We did request a waiver of the peak runoff because we did meet the stormwater treatment standards, and with that, obviously, we have to slow the water down substantially. And these are all just 5 single lots without any internal road. We provided you a packet with all the necessary information. Mr. Lopez is looking for an approval so he can start building sometime this fall. So with that, we'll take any questions or comments, and hopefully we can answer all of them.
I have a question. Can I
But,
answer that up front?
Okay. So before you, well, go ahead, go up. So is the board okay with the public commenting at this point in time? Okay? Yes. So just name and address, Mr. Stone.
Tom Stone, 279 Sweden Road. The first question I have, are there any duplexes being built, or are they single-family homes?
These would be all single.
Okay.
Single-family homes?
Yeah, we would put a note on the plan that our fact is one single-family home per lot.
The other thing is, the drawings that were sent out are illegible. So I think that we need to, so we all understand what's going on, get drawings that we can read. I'd like to show anybody who would like to look at this and see if you can read it.
I don't think I got any drawings.
You didn't get one?
No, I don't think so.
Are you in a butter?
The plan land is, yeah.
Okay.
Oh,
I'm not trying to hold up anything, but
No.
I would like to
Like-
have drawings at home. So when you do your construction, it's according to the drawing that we got, but we don't have a drawing really.
Why don't you show that to, not just me, because I'm only one member. Could you just hand that to the board so they can see it? So, sir, what is your name?
Timothy Cream.
Timothy Cream. Okay, you were on the abutter list. You did not
Can you
receive,
get us all drawings?
you
I
did
don't
not,
believe so.
did you get the abutter letter? Did you get a letter? Okay, so that's what you received in the mail. Okay, you didn't
That's
get a
it.
sketch.
Okay, I agree.
Okay. I don't want to cut things short, but the ordinance does say that there should be a sketch that goes to each abutter. But,
Madam Chair, I believe the letter also says that the drawings are available for viewing at the town hall as well.
yes, but it asks the applicant to enclose a sketch. That's the, let me go to it.
No, I'm not doubting what you say, but it also says that the documents are available to be viewed at the town hall.
Right.
Right, so what they send, I guess my point on this would be, we've got the certified mail receipts that I went to Timothy Cream and Jacob Cream, P.O. Box 38, Bridgton, Maine, 04009. We know the gentleman that spoke earlier, you got the drawings in that same letter?
Yes, I got the drawing.
Yeah, so how do we know it wasn't in there and it was misplaced, or it wasn't, you know, we don't know that. All we can take is the face value that the certified mail receipt went out from the applicant. And you're not gonna get full-size drawings sent to your house, you're gonna get an 8.5 by 11 shrunk down. That's why they're available at the town office for anybody to come in and view at any given time. I don't think we have
But
to.
don't you think that we as abutters can have a drawing at our own home? that
You
we
can
look
come
at?
into the town and
Well,
request
there's the
that.
drawing, you can't
Hold
read
on,
it.
Dan.
I don't wanna change
Why
anything.
shouldn't we as a
I just wanna
butters
be able
get
to
the
read it.
damn drawings? Right.
So let's go to what's required in, okay? How must an applicant give notice to abutting property owners? Whenever a provision of this code requires notification of owners of abutting properties of an application, public meeting, public hearing, site visit, or other filing event, the following requirements apply unless otherwise specified. The applicant must send a notice in a form acceptable to the reviewing authority to the owners of the property within 100 feet of the boundary. For subdivisions, it's 500, affected by the proposal of the town manager. The notice must contain a description of the application and sketch plan, together with the date, time, and location of any public meeting, public hearing, site visit, or other. So it says the notice must contain the sketch plan. The notice must be sent using certified mail, return receipt requested, and then so forth and so forth. In addition, for subdivision and site plan applications, the town must send the notice described in subsection A above to the municipal clerk and reviewing authority, so forth and so on. So I think that, so it is supposed to have, you can come look at the town. That's an option. It is supposed to have the sketch in it.
Right, I guess what I'm questioning is the fact that he got a sketch, did anybody else get a sketch? Was it just one person that didn't?
He's
Yeah,
definitely not an abutter. I might be, or might not be, I can't tell from his diagrams whether I am or not.
What is your
Well,
name?
you're on the abutter list, so that's why you got it. That's why you're an abutter within 500 feet.
Right.
That's why you got that.
And why should we have to go to town?
But that, you know, I can't, that's the rule, okay? So, how's the board want to proceed? Do you want to continue? We do have a situation where we have one person that, we show the envelope, they don't have it. It doesn't mean that, yeah, it could have been misplaced, but if, I think I have to give the benefit of the doubt to the person that received the mail, that it didn't drop out of there.
Madam Chair, you've been doing this for a while. How many times have you had this where one person out of many is missing one
Yeah,
page?
that's what I'm kinda getting at, is that you have a total of 1, 2, 3, 4, 5,
We have
6,
13.
13 abutters,
And only one got plans?
and only one didn't get the plan.
I can't help, there's a first time for everything.
I get that, but I don't think we should hold it up for just that.
Could I make
Okay,
another
but
comment?
in that
You
case,
don't know how many others didn't,
in it,
so not all here.
yeah, folks, can we, let's, need to be recognized to speak.
Excuse me.
So, we have a couple choices. We can continue, we can call a public hearing, and this can be corrected. I will say that if this goes to appeal, it can fail on procedural grounds. So, because we're not having a public hearing. In the past, we've been exceptionally strict about this. I understand what everybody's saying here, but could I have a temperature of, I think I have the temperature of Dan. Could I have the temperature of the other voting board members? Ms. Miller?
Well, I don't think that my position has anything to do with what the abutters or the applicant is presenting or what they think, but just procedurally, if the abutters want to, or if they would like to have the possibility of an appeal, a public hearing would give them a more settled, for lack of another word, settled process that we take into account all of the planning board deliberation and discussion, and that may be more satisfying for them.
Yes.
So
I think.
I have no opinion except that.
Okay, procedurally, and that's what I'm asking is procedurally. Kathy?
I feel as Dee feels that we would like
Yeah.
to give everyone the most opportunity to try to present their evidence and information and give us the best choice for deliberation.
Yeah, I think, procedurally, if we didn't call a public hearing and this were to go to appeal, it could just be overturned, it could be overturned on appeal. I'm not saying it would be, I'm saying it could be purely on procedural grounds. So, because of that one item. Ms. Cook?
I agree with Ms. Miller.
Okay. So.
Can I just say one other thing, which I should have, I am a friend of some of the abutters, so I hesitate in making them feel they've wasted their time waiting to this point of our proceedings tonight, but I am also a friend of the applicant, so that's the benefit of being in a small town.
Yeah. So I think, so here's, I think we can vote to have a public hearing, and I think we should. But I also think for the benefit of the applicant that if the board would allow it, if folks here have particular questions, it could help during the public hearing. So we have the public hearing, we deliberate, we make a decision, if the board agrees with that. Mr. Seymour?
I just have a point. I pretty much know how you're going to vote on this, but I would just like to say, I think if there were to be an appeal, the appeal would be from somebody who's not here, that didn't get ample notice. If it was somebody here who didn't have a map, I don't think they'd appeal on not having a map, because they'd have their opportunity to speak about the project and discuss the project with the planning board. So they had notification to come here and discuss the project. I understand that, because it's on 8.5, 11, to Mr. Harden's point, it's difficult to put a full-size sheet on a deliverable 8.5 by 11 sheet and have it be really clear.
That's why I use the words could, because if somebody goes by the letter of the law on the other board, that's.
Just want to make that
And then
point,
I think
that's
it goes, then it could be set.
I don't think the issue is just the lack of plan.
I agree.
I think the issue is that if the abutters want to, and the applicant, want to take advantage of the full range of activity, they might want to consider that a public hearing would afford them a different level of appeal
Correct.
than without a public hearing.
Won't be de novo. So why don't I'll move that we have a public hearing. Is there a second? Second by Ms. DiPietro. Any further discussion? Let's vote on the hearing first and then set the date. All in favor, please raise your hand. Ms. Miller, are you in favor of a public hearing?
I'm abstaining on this point.
Well,
I'm sorry.
Ms. Miller, you can't abstain after you've discussed it, so you just have to vote. All in favor, please raise your hand. All opposed? Okay, 3-2, we will have a public hearing. Let's talk about dates. So first I would say to the public that if you want to look at the full-size plans, you do need to go to the town office.
Can I just make one more comment? I'm also a civil engineer, professional engineer, state of Maine, retired. I would never give out that little drawing that anybody could read. So all I'm asking is they produce a drawing this big, not that big, just bigger that we could read.
11 by 17?
Yeah.
Well, something that we could actually read. I mean, I couldn't hardly understand what was going on in that drawing, which I'd like back.
So, I mean, I think that's a reasonable request, that if you're gonna attach a sketch plan, the idea of a sketch plan is that you could actually read it.
I could, I mean,
Okay, guys, hey, we
let's
can't,
see what they provide.
okay. Folks need to be recognized, please.
Can I ask another question?
Yes?
Would it be appropriate, even though we're having a public hearing, to have the abutters who are here tonight address some of their major concerns so that the applicant would be
I already
able-
suggested that, I was trying to get to that.
Great idea, Dee.
So, let's pick a date for the hearing. I was gonna schedule, there might be, well, let's wait till all the questions were answered, then we'll find out whether the applicant feels they need more time than a couple of weeks, okay? So what I'd ask is if each abutter that wants to speak to something, please get up and speak to it. You're gonna be able to speak at the public hearing. This is really, you're almost like a board in the sense that you're just giving some input to the applicant so that they are prepared for the hearing, so we don't have any surprises.
I only have one more thing.
You have to go to the mic, please.
I am,
And
I'm heading there. And this is not a negative thing at all. I just want to let the abutters know, but the purchasers, that this is a very wet property, and that about 20 years ago, next to Scott Fixker's house, Bruce Warren dug a trench all the way down the entire property along where Fisker lives to keep the water flushed down like a little river. I mean, that's how bad it was. So I don't know how familiar you are with that ditch. Have you seen the ditch? Yeah. So a lot of water runs down that.
so we could, yeah, they can speak to that at the
Okay,
hearing.
that's all I want.
Okay, so is there anybody here that would like to speak? And really, what we're looking for is if there are things you would like the applicant to address at the hearing. So, Ms., go ahead. I think you're first and then you.
I'm Donna Joss. Thank you, Chairperson Rossini. And I'm an abutter.
Yep.
And I just wanted to ask Mr. Lopez if you are considering the lighting that's going to go into these homes. Can you hear me? If I'm
So
on-
you would
Okay,
like,
I'll face you and he can hear me. Okay, I'm concerned about the amount of light that's going to be brought to this neighborhood, because right now it's really dark, and I'm concerned about the dark skies and our ability to see the stars at night, and also the impact of the light pollution on the animal life, the human life, the life cycles of the people that live there, the animals that live there, and the insects that live there. For example, there are,
so what I'd say, Donna, is,
Yes.
I'm not trying to rush you, but
No, that's
I think
okay.
what I've got is you want the applicant to provide some information on lighting and how it might affect the environment or not.
you got it,
Okay.
yes. One other,
We'll conform to whatever's in your ordinance with regard to
Yeah,
lighting and
so
residential.
just hold that thought for now. All I'm trying to do is help the abutters and the applicant to be more informed so that when we come the next time, we're gonna deliberate, essentially.
okay. The one other thing is the speed limit. There's no speed limit sign on Millbrook Road. And if we're gonna have 3 more driveways, or 2 more driveways, 3 more homes, I think we need a speed limit sign. We have put up our own signs to say, please slow down, there are dogs and people on the road.
Okay, so what I would say about that is, that would have to be just simply, the applicant can't do anything about that, but that would have to be a request from this board to the select board.
So I'd request that the board request the select board
Okay.
to look at it. Thank you very much.
I think it is a public road.
I could be wrong, I don't know.
Is there anybody else? Please state your name. You get to go next.
Yeah, but I'll defer to Ms. Dunn.
Okay, you'll defer.
Stone, and
my husband and I ran a construction business in Miami for many years. I don't know whether, along with this, we should have a picture of what these houses are gonna look like. I mean, it's a beautiful neighborhood.
All due respect, that's not required.
It's not required.
So guys, I
So
don't
you
want
can
to,
build a factory-looking.
hey,
house.
everybody, hold on. I don't want the applicant and
Okay, I
the
didn't know that was,
public to debate each other.
okay.
So,
Just thought it would be nice to
debating.
see a picture.
No, you are, you both are. So what the butter is asking for, what Mrs. Stone is asking for is to get some idea of the types of homes that are gonna be built. So just file that away. I hear what you said, it's not a requirement of the, ordinance, but it sounds like what the abutter is asking about is kind of how it impacts, their potential property. So just,
Well,
that's what
we
I,
just want to keep things beautiful in our neighborhood.
okay.
Yeah.
So
We've all
aesthetics, aesthetics. Okay. Please state your name.
My name is Tim Cream. I live further down Millbrook Road, downhill from the proposed development. What I'm wondering is if the builders have taken into account the amount of water that comes down Millbrook Road and the inability of the current gutters for, that's all, about all they are. They're really not the size to handle the amount of water that comes down. There are three culverts that go under Millbrook Road, maybe four, to handle this water. But when the town does not keep these clean, the amount of water that comes from storms it rips out the road. It's a dirt road. It's hard-packed dirt road, but it's.
So, Mr. Cream, if I understand what you're saying is you'd like to have a very good understanding of the water flow that'll be created from any clearing, the homes, and how it will impact Millbrook Road.
Right, and that maybe there should be a way of getting some of this water across the road before it heads down the road.
Okay, so I think the applicants heard that. The applicant's gonna, their requirement is to follow the standards of the ordinance, and so, we're gonna have to judge it on that, not on necessarily on
The
what
inclusion of roofs and driveways is going to increase the speed of the flow.
We'll have them speak to that, so they've heard that. This again is so they can be prepared for the hearing. And I just note, we don't usually do this. We usually skip this part.
One more.
Oh, it's got one more.
Is there anybody?
One more item.
Oh, sorry.
Our houses are really quite separated in the neighborhood.
Okay.
Some by 100 yards or more. And this is going to change the character of the neighborhood completely.
I think you should hold that till a public hearing. So,
Okay.
and based on the standards, I think applicants heard what you've said.
I didn't know what I was supposed to say.
No, that's okay. Mr. Gibbs?
Ken Gibbs, 27 Millbrook Road. Want to build on what Mr. Cream has been saying, is that there is a quite deep ditch that's on the west side of Millbrook Road. And it is due at the moment for the town to redig it, because it's generally about 4 feet deep. It is quite a ditch. And the runoff from the lots actually fill it when it is dug properly. You know, at the moment, that ditch has filled up with vegetation and has filled up with storm debris. And so there's going to be a question about that. I noticed that in the applicant wants to, says there's no need for a formal stormwater management assessment of the lot. And these lots produce more water than anyone can believe in runoff. In fact, if you look at the soils here are generally saturated almost year round. And during the spring runoff, it's almost as, I can hear the river flowing in the ditch from my house 75 feet
I'm
back.
going to stop you there. I think
Yes.
you've got the point. There's a big
Yes.
concern about the drainage, but there's also an implication here that the town needs to do a better job of clearing those ditches.
And there should be a
And you're asking for a stormwater report.
yes, a stormwater report from a certified hydrogeologist.
Okay. All right. Go ahead.
I'm just curious, a hydrogeologist would not be looking at the stormwater. That would be a civil engineer. I said a hydrogeologist would not be looking at the stormwater report. A civil engineer would be looking at that. A hydrogeologist is looking at the type of soil and the groundwater condition.
Okay. Mr. Gibbs?
Just that our standards refer to a hydrogeologist.
For stormwater?
Yes.
Let's hold on that for now. I mean, I think that the board has fair level of interpretation as to whether a hydrogeologist and a civil engineer fill the same role in that case. And this is not to diss any hydrogeologists, since we have one in the room. Okay. Anything else from the public? Okay, and then just remember, there's gonna be a hearing. So we're gonna do this all over again. I'm really doing this, so the board has really agreed to this so that the applicant can be prepared.
Tom Stone, this spring, so much, our lot is exactly parallel to the lot you're having. So much water came down, it ripped out our driveway, it ripped out our culvert, and all the water and the rocks and the gravel from I don't know where went right across our lawn. Now, the state luckily fixed it all back up and cleaned our lawn up and planted, but the amount of water, it was like a river coming across our yard. But that was a real heavy rainstorm, but that's gonna happen sooner or later. So you really have to take a lot of protection against that.
Okay, thank
Madam
you.
Chair, can I say one more thing?
Yes.
I appreciate you allowing the abutters to speak and voice their comments. It's good that you take that into consideration. I also think, though, that consideration should be given to the landowner who purchased this property years ago as an investment and is looking to realize the fruits of that investment. You have a land use ordinance for a purpose, okay? It was years in the making. It was voted on by all the people, most of these people probably sitting in the room, and it gives standards to applicants for the projects they want to bring before the board. This project meets it. So I think that there should be more of a streamlined process here than listening to, we got to protect insects and.
I think we're done with the abutter things. It really was just to prepare for the hearing. And we really need now to get to the board, if the board needs to see anything for the hearing. I understand what you're saying. We'll try to hold the hearing as soon as possible.
Okay, thank you.
So, in terms of the letter from the hydrologist stating that septic runoff from the proposed subdivision will not adversely affect adjacent property or private water supplies. So that's the letter from the hydrologist, hydrogeologist.
Right, not what they were asking for.
Well, I'm not sure I've gotten there yet. So before we go any further, is there anything the board feels they need as evidence for the public hearing? Kathy?
Yes, I was wondering if you might want to think about revisiting your phosphate calculations
We-
in light of the fact that this is a shared driveway, which is over 150 feet and pertains to become a road.
Yeah, we did, but we took into account that it's a shared driveway, so we kind of split the difference between that and the other lot because we used a computation for single-family lots. So if you take the balance of the shared lot against two lots, then we felt it was the same impervious impact.
Yeah, but I did the calculations and came up with quite a bit different.
You can do it many different ways and come up with several different
Right.
uses, but we can take a look at it again.
I think what she's asking is to take a look at an alternate method, does it still pan out?
Right. And yes, I was going to request full stormwater, just given the amount of
And I would just like,
wetlands that you
if I could on the stormwater aspect, a lot of the runoff, I get that the soils are seed soils. There's a pocket of wetlands down on lot one. But the impact from most of that stormwater comes from off-site. It comes down Sweden Road viciously in a heavy rain event, causes a lot of washouts. And there is a turnout ditch that comes down along that common property line with the Fisters. So a lot of this water does come down Sweden Road. I understand the abutters' concerns because we had a heavy rain this last May, and there was a lot of damage down there at the intersection of Crotched Pond and Millbrook from the runoff coming down Sweden Hill. It's a big area that contributes to that, but I think what we'll find is a lot of the influence of that is off-site water, even above us, but we can take a look at that.
So there is a standard here that says documentation of adequate provision for the collection of and discharging of storm drainage in the form of a drainage plan prepared by an engineer that demonstrates changes in the hydrologic conditions will not cause off-site flood damage to public or private property. Changes in runoff must be calculated using the TR 55 method or subsequent approved methods developed by USDA Soil Conservation. So it is up to you, but clearly there's a lot of questions about water runoff.
And we did have a conversation with the Public Works Director, but we can revisit that and take a look at the
Yeah,
calculation.
I mean, if not,
We did, if you look at the design, we did include two 24-inch culverts with substantial piping, so that water
Okay.
would be conveyed, but we will revisit that.
you may want to, just
Yep.
reevaluate
Sure.
that.
Right.
Okay, is there any,
One other thing. Were you considering any sort of deed restriction on the lots 1 and 2 that share that driveway in terms
Yes,
of how
there
the
will be.
maintenance would
Yep.
be?
Mr. Lopez will have some kind of owner's agreement between the shared driveway.
we would want that.
Yes.
Right.
Okay? Dee?
I was just wondering if there's any infrastructure that is installed as you look at this, according to what Kathy has suggested. Would there be any features that would necessitate maintenance by a homeowners association?
Currently, with our design, we've utilized buffers. There would not be any maintenance required, just a restriction that they couldn't cut
Yeah.
that. If we relook at that and we have to add some other feature, then there may be some requirement by the landowner, depending on where it's
So,
sited.
okay, so to be decided. Mr. Harden?
I just have a question, because I don't know the answer to it. Is Millbrook Road public road,
Yes.
town-owned?
Town-owned road.
Okay, and Crotched Pond is a private, correct?
Correct.
Okay.
Okay. Angie, how about you? Ms. Cook?
That was one of my questions.
And I think I'm all set. So let's determine a date. How much time do you think you need, given what you've heard tonight?
Probably a week.
A week, okay? So you need to have anything you turn in, including you need to give 12 days' notice, and in that notice, I would put in improved sketches. I would also, just say to the public that sending the giant ones is not called for, and the applicant's going to try and send you something readable, but if you can't read it, you're going to get this 2 weeks in advance. I'd really advise you contact town staff, and they'll send you an electronic version you can blow up on a computer, or you can come into the town office. Not all the applicants, not all of us pick up, or not all of us use them, so if we have an extra, staff can give it to you and you can share it. of the largest ones. Okay, so that's my suggestion. All right, so if you need a week to get your stuff together, and then we need essentially 2 weeks to notice, we're 3 weeks out. So the choices are August 1st, or we try to go before that.
August 1st.
You want August 1st?
The only question, yeah, we also have Maker's Mill that night.
So there are 2 public hearings.
Yeah, I would say let's do them before, because I think this one won't go as long as, because Maker's Mill is gonna be first. And then we've got them, so those 2 public hearings have to go first. And then whatever other applications may sit here for 3 hours, and then we kick them.
Okay, so we should talk to Mr. MacGyver about whether he's okay with going second on the public hearing.
Well, I was gonna suggest, could we do everything by the 25th? And have a meeting on July 25th?
It sounds like they prefer the August 1st.
Mr. Lopez will not be here on the 25th, and he
Okay.
would be here.
So I think we stick with August 1st. And I think if we have a big agenda, that what we have done in the past is in advance had a rollover day, which would be August 3rd.
Okay.
Okay? So any questions from you?
No, we'll just start working on some of these questions that were raised this evening and provide you some updates and make sure that everybody gets a map or a sketch this time.
Okay. And Mr. Harden has offered to give his large-scale plan to the butters.
Yeah, I believe
So has Ms. Cook.
mine's either here, I don't know if Laura Lee might know, is it mine still upstairs? No,
I'll
so
give
it's at my
I'll
office
give
then.
mine and you'll give me yours.
Yep.
Yeah, so I think folks should share that. And I can use, I do want yours because I didn't use the large plans. Okay.
I'll have one, take yours back, if they just got 3 more.
Ken, here's another copy. Here's another copy.
Deb, I would take yours back.
I've drawn all over it.
Kathy, keep yours, because you're the only one who knows what to do with it.
Well,
That's mine, because I've run the digital. I can read.
whether that, doesn't matter how long.
Yeah, I take out my color.
Okay.
crayons and I say, okay, that's 75 feet, that's this, that's visible, that's setback.
All right, everybody, we need to move on.
Folks, hang on.
Hello?
Yeah, and we'll keep it.
Yeah, it's a rowdy crowd.
Yes.
Next on the agenda, hello, everybody. I got to quiet down here. Thank you. Well, these people home. Are interested. Okay, on to the next order of business, 10 Lakes Medical Complex, Portland Road, map 10, lot 3.1 and 3.2. Folks, I cannot hear.
Folks,
Hello, hey, guys,
guys,
we can't hear.
we can't hear up here.
They can't hear either.
I know.
Mr. Seymour, you're presenting again,
Yes,
right?
yes, I am.
Okay. 10 Lakes Medical Complex, Portland Road, map 10, lot 3.5, 3.1, and 3.2. This is a pre-application, and where did Mr. Gibbs, oh, there he is, he's back.
He's back at the table.
He's back. Thought he disappeared into the bathroom again. Okay. Thank you, guys, for your interest. Yeah, I'll go by that.
Well, I cleared the room.
Although maybe I should go by Madam Chair, because everybody's so rowdy. All right, so this is a pre-application meeting. This is not a formal review. In their letter, the applicant stated the sort of input they were looking for, so if you could just give us a description, and then the board will provide non-binding advice.
Yep. Thank you for accepting us this evening for this pre-application sketch. Again, I'm Jim Seymour with Sebago Technics. With me this evening is Dr. Derek Egan, of 10 Lakes Wellness Center. What we're looking to do is build a new wellness center located on Portland Road. This is actually 2 lots east of where Napa was recently built. To give you some context, almost kind of diagonally across from the drive-in. On this property, there are 2 lots which consist of 6.51 acres. Mr. Egan is looking to develop 8,200 to 8,500 square feet of building. We've given you a sketch plan which shows the approximate layout we're looking at with parking to support the wellness center. Because he owns the property, as you're looking at that plan to the left, some of the stormwater features will go on to that lot. In this location, there is no sewer, there is currently no water. We did have a discussion with the Public Works Director with regards to the possibility of having sewer extended up through there. Big time cost to run it up the middle of 302. We're looking at over $500,000 if we want to extend it up through there. So that one was kind of ruled out. So we'll be looking to do on-site subsurface design. Most likely that'll go under the parking lot or into that grass area that's just behind the building. Water, there is a water main down at the intersection of 117 and 302. We're in discussions now to see if we could possibly run that up and cross 302 to have public water to this facility. We haven't made that decision yet, but we're in conversations about that. So we have a nice building. I actually have one of his first renditions. It won't be the final, but I can give you some context of what the building is like. We're looking to have 50 cars in this parking lot. Dr. Egan is looking to possibly stage this building in 3 phases. He would build the shell in the first phase, fill the middle, and then fill out the ends as the businesses come into his plan. So with that, I just want to understand if there's any other impacts. This is in a corridor district. If there are any concerns, questions, or anything like that, this will trigger a main DEP stormwater permit, given the size. I know before this was, I believe, a motorcraft boat location that you had reviewed or started to review. Similar size, so we'll have to file for that stormwater application for phosphorus and for stormwater. So I'm just going to flip the sheet over just to give you kind of a rendering of the building.
Okay. I don't think we ever reviewed the boat one. It had to go to the appeals board for a variance. Yeah, so obviously he didn't follow up on it.
I know he filed the stormwater permit, but I know it didn't go very far, So this is just kind of a sample of, I think that curved whale tail roof may be trimmed and be more angular. But this is kind of a concept that he has for what he's looking to do for his wellness clinic. And I think, there will be, that end wall will be the one facing 302, and we had discussions about putting windows and things in there to give it some character as well. But I think the colors, the roof lines, will make it an attractive location.
Anything else?
No, we'll
Okay,
just
so-
take any feedback.
Feedback from the board and specifically, things that are, I think, whatever the applicant asks for input on, if somebody has the letter right here. Initial input, concerns for any impacts, and to review future schedules and site plan application, focus on certain items. So if there's particular standards or other items?
I just didn't know whether this is I wouldn't say a substantial commercial building, but it's gonna add some impact. They're currently located on 302, just down the road, so we're really just kind of displacing traffic load further down 302. We don't anticipate that this will trip a traffic movement permit, but obviously those trips go through the intersection of 117, and didn't know if there was anything the town had concerns about with regards to the impact of that.
I would put in there some sort of traffic analysis. There's been a lot of attention at that intersection, and I think other applicants, Ms. Day might be able to speak to this, but I think other applicants have gotten feedback from DOT to have some sort of analysis.
I know that is, I don't know if I don't want to put words in anybody's mouth, but I know that's being investigated for potential future light there.
And I would think about also, although you may be displacing the traffic from one area to the other, there's people like myself that are having one heck of a time finding good primary care in this town. So no diss to any doctor in this town, that's not mean it, but it's very difficult because,
Yeah.
and so, you know, information about number of clients and, you know, how that impacts traffic, I think that's, you know, I would pay some attention to that. There's been a lot of attention in that corner.
We can put together a traffic analysis and just give you an idea of what we're generating and the impacts.
How about others, Ms. Kathy?
Yeah.
And then Dee?
I want to look at your overlay district maps carefully with all setbacks and other ramifications of those, because I believe that you're in the limited commercial wetland. And I also see you have wetlands delineated there, but it didn't look as though you had them delineated. They were delineated by
Mark Hampton.
Mark Hampton?
Yep.
Okay.
Hampton Associates, and we have received, those were done for the previous application, and we have received those from Mark to reuse.
Okay.
Yeah, I think, just to tag on to Kathy, if in fact, when you look at the overlay maps, the shoreland zone is different from what you're seeing as showing here, then the delineation could become very important.
Okay.
Ms. Miller?
Yeah. Excuse me. I was wondering if you could give us some indication of what type of practitioners, how many practitioners, what their individual schedules might be, just so we would have some indication.
Yeah, you don't actually have to answer that
You don't
tonight.
have to answer it now.
You don't need to answer it now. She just needs to.
I can tell you now if you want.
So that, you have 50 parking
glad you're ready
places,
to
but
answer.
how are people going to be coming and going at what rate, during what periods? Or is it just going to be one practice where so I think that would be interesting.
Yeah, so.
I can give you a quick overview. I know it's getting late, but it's going to be multidisciplinary. Several chiropractors. There'll be several medical doctors and nurse practitioners filling in a primary care, as you mentioned. There'll be massage, acupuncture, different holistic or wellness ideas. The grand idea of it is to bring in practitioners that already exist in town, bring them together into one spot. That way, it's easier for people to get not only find us, but also for us to refer back and forth to each other, and start out with 8,000 plus square feet and go from there.
Okay, so, yeah, just, I would include that in any update. And if it affects, in any interaction with, number of clients and the amount of parking you have and traffic circulation, I noticed on there that you've got an area designated for, potentially for future parking.
Yep.
Maybe you want to speak to when that would be, if and how that would be actuated.
And that would all be dependent upon, again, to your point, that whoever the practitioner are or their level of service or needs. Initially, we're just looking at this as the most simplistic, but obviously if there's an expansion or change of use, they have to come back to the plan.
Absolutely, yep. Mr. Gibbs?
Yes, perhaps it's an optical illusion in looking at your drawing there, but the roof and the gables seem to be extremely high.
Oh.
And is it going to be within 35 feet?
Yes.
And is there a second story?
There is no second story. It would be a cathedral-type ceiling in there, and it does not exceed the 35 feet height.
Something to make patients feel comfortable when they walk.
It could be an attic or maybe a crawl space, storage space above, but it was not meant for use or habitation.
Okay. Ms. Cook, anything you want to see? Mr. Harden? I'll come back to you if you had more.
No, I'm good.
I have a couple things, but did you folks have anything else? Go ahead, Ken.
Yeah, can I just ask, will there be a connection with the Bridgton Hospital?
No, it'd be completely independent.
Just obviously, you're doing a stormwater report,
Correct.
and so we'd want to see that. it's okay if it's what's submitted to DEP?
Yes, absolutely. Yeah,
And
the town
of
gets a
course,
copy
the
anyway.
phosphorus export.
Yeah, and that's what we'd be looking at. We'd be looking at the phosphorus export. Town, once we file with the DEP, the town automatically gets a copy, but we can make it presentable to
Right.
the planning board as well.
And then, I think in that district, in terms of landscaping, I forget exactly what it says, but, one second, I'll find it very quickly here.
We did have, I'll put that plan back.
Landscaping. Yeah, so you should have a landscaping plan, when it sounds like you have the beginnings of one there. And I would just note that it's one of the things people pay a lot of attention to, even
Yeah,
along that corridor.
Absolutely, with any medical or wellness center, you want it to be attractive and nice on the eyes, and Dr. Egan is going out of his way for an attractive building, and we will definitely, we've got some trees in the parking lot, but we'll dress it up. That's the
Yeah.
one difficult thing, is with the proximity of the building so close.
I know.
It starts to limit what you can do
Yeah,
in front.
I
So maybe
understand.
there's some low landscaping against the foundations or things like that, but obviously we don't want to block the building.
Yeah, I totally underland. It's an interesting, it's interesting that those three are in the inner corridor. Maybe it makes sense because of the settling.
Yeah.
And then, as with anything, just make sure you go through, and I know you will, because you do this, I know you do this for other towns. Just make sure that you go through all the submission requirements. And, you've covered all of those bases, and obviously make sure all the abutters get noticed. Ms. Miller?
So this is an application for phase one?
This will be an application for the entire project. If he wants to expand the building in the future, we'll come back, but he's planning on that. What you see on that footprint right there is what we're planning for right now. The interior may change, how he fills up the interior will be phased, but from a site plan perspective, it's one site.
So this building is going to go up in
Correct.
total?
In total, correct.
At one time?
Yeah, at one time.
So what you might do is just, it might be helpful to just,
We can make
because
some
if you had a change, obviously if you had a change of use, you'd have to come back.
Right.
So it just might be helpful to give us some color around,
we'll
where you
make
say
some-
phase two and phase three, explain that a little more.
Yeah, and it'll obviously be medical related or wellness related, so we can make some assumptions of parking based on similar use would be going in the middle. I think it's just a matter of, how many practitioners we get in there, but that too is a revolving schedule. They don't all come at once, so
Right.
it's kind of nice that way.
Right. I think the big thing is maybe, unless you're envisioning something could totally change, is just to declare the use for what uses you want to have approved
Yeah,
for the entire building.
We're gonna declare it as medical and go from there. The exact details of that may change, but
Right.
it'll be under the medical umbrella.
But, as you know, there's certain triggers, things that trigger amendments.
Absolutely.
So just, sort of thinking ahead. I'm not
And
saying
we have to
that
make
that would
those
happen.
Yeah, and those assumptions come forward with traffic and with our septic design as well.
Yeah. And, anybody else? Ms. Miller?
I was just thinking of the scope of what you're doing. I mean, you're not going to be doing, are there going to be extensive labs and any surgical, where there'd be waste products or things?
A very, very small dry lab and clean lab that a primary care would have in their, any primary care would have in their office.
Okay,
So no big labs.
so there'd never be those problems of disposal of toxic waste?
No blood work.
So blood draw will be done at they'll be referred to Bridgton Hospital for blood draw. The only
Okay.
thing they'll be doing in-house would be like immunizations or like mole removals, that kind of stuff. So nothing outrageously
Yeah.
waste product driven.
Sounds a lot neater than what you, okay. Thank you.
Anybody else on the board? Do you have any questions for us?
No, obviously our goal is to get this into the DEP, they're the longest lead time, and, we hope to be back early fall with some results of that, and he would like to be able to at least do some preliminary work before the snow flies. That's the
Okay.
goal.
Great. Well, early fall, hopefully it won't be quite so busy.
You and I hope you
It'll be a
won't.
lot easier for us to schedule things.
Thank you very much.
Thank you
Thank
very
you.
much.
Thank
you. Appreciate all the time that you've spent here tonight.
Must have been fun.
So next on the agenda is other, and And I would just like to mention two things. One is, I did want to call a workshop and get back to our ordinance work. And what I'm thinking right now is, we'll polish off what we agreed to on LD 2003. We had that prepared for June and didn't do it. So I'll make sure that everybody understands what to review there. And then, and then after that, I think if we have time, I think we should go over the evergreen list and do some prioritization, and I will talk to Tori about helping us with that. And the other thing I wanted to say is relative to that, Ms. Day, whom I have to compliment, she somehow figures out how to do these things. Because of the analysis some of us wanted to do with LT 2003 on lot area per home, Ms. Day has actually worked with whoever it is you work with to pull out of our data systems every district and every lot in every district and how big it is. So I know I'm gonna find that immensely helpful. And Angie, you don't know this, but each board member got an assignment to analyze lot area per dwelling unit. And we wanted to kind of understand the districts, or at least some of us did. Some of it might end up being common sense and knowledge. But I just wanted to publicly thank Ms. Day. That information will be in your OneDrive at your disposal. I actually can't believe that she pulled it off. Good job.
It wasn't really me.
But it was you that made it happen.
Take the credit.
Do we have new deadlines now?
No.
We do have new deadlines. The state did, and the governor signed into law, July 1st, 2024. We need to have an ordinance that meets LD 2003. There were some modifications to LD 2003. There will be new rules. I'll bring that to the meeting, but my view of it is that we do not need to wait for the state to modify the rules. It's pretty straightforward what was modified, and one of the items was fixing a Scribner's error, so.
So taking into account the fact that our town meeting is in June.
We need to be done, we need to have it in the select board's hands, ideally, by early March. Which means we need to be having public hearings January. So, the goal I would suggest for us is to not get too overly complicated, but to quickly agree on the specifications we started working on, and then start to get, maybe have legal look at that, but I think we really should start getting the public heavily involved in commenting on it, so that we're not waiting for a public hearing in February to discover there's some issue we haven't thought of, and then we don't have time to respond. And with that,
I'll make it a motion to adjourn.
motion to adjourn by Mr. Hardin, second by Mr. Gibbs, just beat out Ms. Cook. All in favor, please raise your hand. 5-0.
Raise your hand for that.